I'm a resident fellow at the American Enterprise Institute. I want to welcome you to today's conversation on the Southern Manifesto, which turns 60 this week. Many of you had an opportunity to attend an earlier event we had last year. We talked about Brown v. Board of Education at 60. A number of people are familiar with Brown, but very few people are actually familiar with the Southern Manifesto. So we thought it was important in the week that it will turn 60 to have a conversation with scholars, with advocates, and with program officers to say, what can we learn from the past, how will it shape today, and what can we think in the future? Today we have 3 panels, and we will have a very good conversation. We have one panel which will focus on law, language, and the past. For those of you who are in the viewing audience, I'm going to welcome you as well. At the conclusion of today's event at 7:30, the entire event will upload to our webpage, so you can watch at any point you want. I will ask those who are here in the audience to make sure you silence your cell phone so we do not interrupt our speakers. Also want to let those know who are in the viewing audience that hashtag Manifesto60 is what you can use. Periodically, we will also take questions from those who send us questions. So if you hear something great, make sure you send it. So we're now going to move into our first session. We've got 3 very well-qualified people to talk about the Southern Manifesto. I will introduce each speaker in the role that he or she will speak. First is Dr. John Kyle Day. He is a professor at the University of Arkansas, Monticello. He is the author of a very good book that I actually had a chance to read. And in fact, in doing research for this, I ran across his book and looked at a few online videos and said, this guy's got to open us up because he knows a great deal about the subject. In front of him right now is a book that he authored, published by the University of Mississippi in 2014. It's called Southern Manifesto, Massive Resistance and the Fight to Preserve Segregation. And he will open us up today with a conversation about Southern Manifesto and what it means, and then we'll move to our second speaker, who is Professor Justin Driver. He is the Wyatt Professor of Law at the University of Chicago. He is a scholar of constitutional law and theory. He also clerked with former Supreme Court Justice Sandra Day O'Connor. I had an opportunity, a colleague of his at Yale, Dr. Akil Amar, said, if you're going to talk about the Southern Manifesto, you've got to talk to Professor Driver. He's got a great article, which I had a chance to read, and he's going to use that as part of his dialogue about Southern Manifesto and the role that lawyers played in this. We're then going to hear from our last speaker, who's Danielle Holly Walker. She is the Dean of the Howard University School of Law. She also works in the area of constitutional law, particular focus on education and inclusion and the role of management in schools. In an earlier life, she wrote a thesis where she focused on Charles Hamilton Houston and the role of Howard University producing social engineers. And it was a number of those engineers who used the law to help untangle over a century-year-old process of segregation in the United States, and she will discuss that as well. For those of you who are wondering what the Southern Manifesto is, on the 12th of this month, 60 years ago, 101 members of Congress signed what is known as the Southern Manifesto, but they called it a Declaration of Constitutional Principles. And really quickly, what they said is that the Supreme Court was outside of its jurisdiction in telling states that they had to integrate their schools. And they said the South will not tolerate it. 101 members thought it was important. They signed the Southern Manifesto, and that gave what I call the ideological green light to a massive resistance movement in the South, which fundamentally changed not only opportunities for African Americans, but also for white children as well. And as we move further into the night, we're going to have a conversation with someone who knows this story quite well. What we will do is I will turn it over. Each person will have up to 10 minutes to present his or her work. We will follow by a moderated Q&A with myself. I'll make sure I sit close to them to ask the tough questions. But, you know, in all fairness, this is a think tank. We have good questions, not tough questions. And then we're going to open it up for a Q&A. There are 2 things we do here at AEI. Number 1 is start on time. And number 2 is to ask that when you ask a question, give your name and affiliation, and then ask a question. At the point that I feel that we are going to hear a sermon, then I'll likely have to move over to someone else. So with that, we're going to turn it over to Dr. Day, who's going to open, and look forward to the first panel. Dr. Day. You can actually do it from there if you like, or you can come up to the podium, either one.
I'm come from the podium?
That's fine.
If I could switch, that might be easier to do.
Great. Just make sure mine is turned on.
Okay. To flip this, my PowerPoint, I brought in some PowerPoint. This just flip. Okay, great. Thank you all for having me. I'm very honored to be here. Thank you to Miss English and to Mr. Robinson and the American Enterprise Institute. You all have been very gracious hosts. Our time has been great here in Washington, D.C. We're staying at the Topaz Hotel, which for me, coming from Southeast Arkansas, is a really interesting. They were telling me last night that was Eleanor and Franklin Roosevelt's residence when he was Assistant Secretary of the Navy during World War I. So it was really kind of historic. I guess Miss Mercer stayed over a couple times too, and at that period of time. But thank you all very much for your graciousness. On March 13th, 1956, 99 members of the 84th United States Congress promulgated the Southern Manifesto, formally stating opposition to both, one, the most important judicial decision in American history, that of Brown v. Board of Education of Topeka, Kansas of 1954, and two, the most important social revolution in American history, that of the Civil Rights Movement. Now, while historians recognize the name of the Southern Manifesto and agree on these basic facts, the document remains largely misunderstood. Historians do not agree on who conceived of the statement, who wrote it, or its implications for post-war American history in general and the Civil Rights Movement in particular. Most of the prominent members of the U.S. Senate's Southern Caucus claimed to play a part in its drafting, while some alleged that they conceived of the project in the first place. Indeed, we largely have taken these politicians at their word. Now, I will suggest to you that if not the greatest, the most immediate impact of the Brown decision was within the realm of national partisan politics. Now, most Americans assumed that Southern school districts would take about 1 year to comply with the desegregation edict. Brown's corollary, declared the following year and widely known today as Brown II, declared that Southern districts had to desegregate with all deliberate speed. Incidentally, this timetable made the first school year of planned large-scale desegregation coincide with the 1956 national elections. Now, by the end of that first academic year of 1955-1956, after Brown II, approximately 10% of Southern school districts complied with federal desegregation orders. That winter witnessed seminal events in the early stages of what we recognize today as the classical civil rights movement. These include the Emmett Till lynching, the Montgomery bus boycott, and the riots at the University of Alabama in Tuscaloosa over the admission of Autherine Lucy. All of these brought the struggle for black freedom to international attention. Simultaneously, in January 1956, the opening of the second session of the 84th United States Congress brought a series of civil rights and education appropriation bills out of committee for formal consideration by both the House of Representatives and the Senate. Namely, the legislative package sponsored by Democrat Thomas Hennings of Missouri, which ultimately became the basis of the 1957 Civil Rights Act, as well as the massive federal appropriation to education, then known as the Kelly Bill, which was pushed through the Senate by Democrat John L. McClellan of Arkansas. Both of these legislative packages face major obstacles. Hennings's bill was controlled by the chairman of the Senate Judiciary Committee, James Oliver Eastland of Mississippi, who by that time was known as the bête noire of the civil rights workers. The Kelly Bill, which had broad bipartisan and interregional support, was conversely threatened by the attempt of U.S. Representative Adam Clayton Powell, Jr. of New York to deny federal funding to school districts that openly defied the Supreme Court's edict. As a result of this favorable political climate for civil rights, Southern congressional incumbents feared that their white constituents would support opposing candidates in both the 1956 Democratic primaries and the general election if they did not block both Brown's implementation and the consideration of these transformative civil rights bills. Specifically, another third-party movement threatened the Southern congressional delegation if the Democratic Party formally endorsed Brown and supported federal civil rights legislation. As in the 1948 Dixiecrat Revolt, another Southern third party devoted to states' rights and white supremacy would again be led by Senator J. Strom Thurmond of South Carolina. This potential Dixiecrat redux promised to be even more powerful than its predecessor 8 years earlier, especially in the 5 states that adopted interposition resolutions that nullified Brown within their borders. This would split the Democratic Party to the advantage of the popular Republican incumbent, President Dwight David Eisenhower. Such a scenario inevitably produced a major turnover in the South. Republicans and/or intransigent segregationists would be elected throughout Dixie, defeating Democratic incumbents. Consequently, the South faced a loss of control over congressional committees, the basis of its federal political power, and the bulwark of the Southern caste system. The Democrats, moreover, would lose not only their thin congressional majorities, but possibly faced a major political realignment, whereby the New Deal coalition disintegrated and the democracy became the nation's minority party. Now, who wrote the Southern Manifesto? Now, at the time, Thurmond promoted the mendacity that he alone was the principal author of the document. Here, in a carefully staged publicity photo he distributed to journalists, Thurmond poses with his first wife, Jean Crouch, as he supposedly dictates the Southern Manifesto. This is actually a phony photograph, okay, staged for the press. Most contemporary journalists and later historians also believe that Democratic Senator Harry Flood Byrd was a co-author. My research shows, however, that Byrd was at home in Virginia most of the spring of 1956, tending to his ill wife. By that time, the consensus, too, was he was clearly past his prime and not much of a force within the Southern caucus. Now, I label this group of Southern senators, led by Democratic U.S. Senator Richard B. Russell of Georgia, as the Southern Caucus. They were dubbed by the press as the Dixie Study Group, while they called themselves the Constitutional Democrats. Now, I argue they should be treated as a true inter-party legislative voting bloc, especially during the era of Russell's leadership from 1948 to 1971, with specific criteria and rules for membership. Now, the Southern Caucus assigned a drafting committee consisting of Russell and Democratic Senators John Stennis of Mississippi and Senator Sam Ervin of North Carolina. Both Russell and Stennis had helped draft the interposition resolutions of their respective states, while Stennis and Ervin were both former judges and thus intimately familiar with the judicial precedent pertaining to Jim Crow, white supremacy in general, and school segregation laws in particular. Now, the drafting committee produced a document that declared Brown as illegal and an illegal and unconstitutional decision, and openly questioned the competency and integrity of the Supreme Court justices. When this draft circulated within the Southern Caucus, an informal revision committee emerged consisting of, from top and left to right, at least Democratic Senators John Sparkman of Alabama, Russell Long of Louisiana, A. Willis Robertson of Virginia, Price Daniel of Texas, J. William Fulbright of Arkansas, and Spessard Holland and George Smathers of Florida. The revised document focused more upon judicial precedent and removed the more inflammatory language so as to successfully harness state-level defiance of Brown to shield Southern national office holders from charges that they were soft on segregation in the summer primaries, ensuring their continued dominance of congressional committees. The revised statement's language was framed in such a way as to satisfy both intransigent segregationists, those who advocated formal defiance of the federal government, and so-called Southern moderates who, though intellectually, politically, and socially committed to segregation, nevertheless believed that formal opposition to Brown was both futile and irresponsible. I'm out of time, but I'll conclude here. The Southern Manifesto thus produced a moderate national consensus towards the civil rights movement. This statement allowed the white South to dictate the interpretation of Brown II, setting the slothfully circumspect timetable for the implementation of public school desegregation, with the consent of both national political parties. The Southern Manifesto also provided the Southern Congressional Delegation with the means to effectively delay federal civil rights legislation so that the destruction of Jim Crow would ultimately be on white Southern terms. Thank you very much.
Okay, so I'd like to begin by thanking AEI and Mr. Robinson for convening this conference in order to remember the Southern Manifesto at 60. Anniversaries from the civil rights movement are a ubiquitous feature of our national discourse. Brown versus Board of Education, the Civil Rights Act of 1964, the Voting Rights Act of 1965. Obviously, at the risk of stating the obvious, I do not come to celebrate the Southern Manifesto in any way, right? I deplore the Southern Manifesto. Nevertheless, I think that it is a mistake to simply turn a blind eye to the Southern Manifesto and to ignore its continuing resonance in America today. It's very easy to think that that is part of a bygone era that has no connection whatsoever to where we are today, and I think that's exactly wrong. So I'm going to tell you why. Okay, so I'm going to talk a little bit about how I came to be invited here. As Mr. Robinson said, I've written a law review article called Supremacies and the Southern Manifesto that's in the Texas Law Review from 2014. And so how I came to write that article I think is worth saying. I was writing a book review, a short piece for a magazine, and I wanted to talk about the Southern Manifesto, and I wanted to say that it was sort of an incendiary instance of racial rhetoric that was open in its bigotry and its disdain for black people. And so, happily for me, I went to read the manifesto, which was reprinted in newspapers all around the country. I have a copy of it here. I feel a little like Joseph McCarthy or something, right? But I have a copy of it here, and it ran in the New York Times. And so I read the Southern Manifesto, and I make it through once, and I don't find the really pungent language that I'm looking for, the open racial bigotry and the assertions of sort of black intellectual inferiority that I just knew were there, right? So I'm thinking maybe I'm tired, I need to read it again, and I go through again, and it's still not there. And so it made me think that the traditional conception of white supremacists as being unsophisticated and overt and jumping up and down and screaming sort of never is too simple, at least as it goes to the Southern Manifesto. They affirmatively eschew the racial bigotry that was part and parcel of even respected segregationists of the time who would make appeals to, black criminality or a black propensity for venereal disease or black intellectual inferiority. One reads the Southern Manifesto and sees that nowhere near there. What does the Southern Manifesto consist of? It is overwhelmingly a legal document. It makes arguments about constitutional text. You will not see the word education anywhere in the Constitution, therefore it's improper that the Supreme Court issued the decision. You will see arguments sounding in originalism, right? The original understanding of the 14th Amendment was that it had nothing to do with schools. That's why the Congress that framed the 14th Amendment had segregated schools in Washington, D.C. You'll see arguments about precedent, right? They talk about Plessy versus Ferguson, obviously, and Gong Lum, a case from 1927. And then they have other arguments about constitutional structure, including notions of federalism. And it's not surprising that this was an intensely legal document because the individuals who framed the document overwhelmingly were lawyers, and well-educated lawyers at that. Strom Thurmond was a lawyer. He didn't attend law school, but Sam Ervin, senator from North Carolina, is a graduate of Harvard Law School. John Stennis of Mississippi was a graduate of the University of Virginia Law School. Russell of Georgia was a graduate of the University of Georgia. So these were very sort of fine lawyers who knew how to advance legal arguments in order to advance their cause. I came to, over time, to think of the Southern Manifesto as in many respects being the missing dissent from the Brown versus Board of Education itself. As many of you know, Brown was unanimously decided there is no dissenting opinion. But what this piece does in fewer than 1,000 words is say Brown was wrongly decided. And when one thinks about what motivated Chief Justice Warren for writing the opinion in Brown as he did, you can see similarities and echoes of the Southern Manifesto. So Warren said that he wanted to write the opinion, and these are related reasons, right, in order to be non-accusatory, right? He doesn't want to alienate the South. He was keeping in mind, so that's partly about tone, being non-accusatory. He was interested in audience as well, right, that he doesn't want to get the South all riled up. And then he wanted to think about unanimity as well. He thought that it would be most powerful if the court spoke with one voice here. And these same considerations are in the Southern Manifesto. As I said earlier, it eschews open appeals to racial bigotry in order to be non-inflammatory. Where Brown is directed, not least toward the South, the Southern Manifesto was overwhelmingly directed toward the North, and those two things are related. They thought that in order to be able to vindicate their vision of race, that they needed to be able to not turn off white Northerners who would encounter the Southern Manifesto in, say, the New York Times or lots of other newspapers. And finally, they wanted to be unanimous as well. And these things are all related as well, for precisely the reason that Professor Day suggested, that in order to avoid alienating people, you have to use relatively mild language. So, it's important to remember the context against which the Southern Manifesto is issued. Brown, too, is the most recent word there, where the remedial decree says desegregation is to occur with all deliberate speed. And so that's a notoriously vague statement, and the Southern Manifesto can be understood as attempting to shape how Brown 2 is going to be played out in the lower courts. As I say, they were intensely lawyerly. They paid attention to lower court decisions, including from Judge Parker in Briggs versus Elliott, saying, people misunderstand what Brown means. It does not require integration, it merely forbids segregation, all right? So this is an effort to, what one of my colleagues has referred to as to tame Brown versus Board of Education and to minimize the potentially radical vision of Brown requiring affirmative steps and racial integration. So they had a few different aims. They talked about, we want this decision to be reversed, right? We can intimidate the court into not continuing down this road. And they also thought we can block justices who believe that Brown was rightly decided. We'll be able to use our sway within the institution and in the Senate. They also talked about the notion of a constitutional amendment. That was the right way to get the Brown decision, they say, in the Southern Manifesto, and maybe we can get a constitutional amendment. That sounds far-fetched today, but it's important to remember that at the time, Brown did not enjoy the sacrosanct status that it has today. Indeed, in 1959, Gallup took a poll and said, do you think that states should be able to determine for themselves how our schools should be set up with respect to race? And a majority of people, a clear majority, 59%, said yes, this should be left up to the states. Now that's short of the requirement for a constitutional amendment, nevertheless, people were sympathetic to the idea that this should be a local matter decided by the states. They also said that we could achieve their goals through gerrymandering, right, drawing the districts in a way so as to reinforce single race schools. And they also said, hey, whatever works in Harlem, New York, in order to make those schools all black, we will be able to import down here to the South. Okay, so they had lots of arguments, and they were, again, incredibly flexible rather than intransigent in their defense of segregation. So in my remaining time, I want to quickly say that the Southern Manifesto does have an important connection to the modern world. So Senator Ervin of North Carolina says, as the Southern Manifesto is issued, that Brown is a deplorable decision, but it's also not as drastic as people think, right? So there's a two-pronged approach. Brown's wrong, terrible decision, but it's also not as drastic as people think. That it doesn't require integration, it merely forbids segregation. So that's what he says in 1955, and over time, he would just put all of his eggs into the not as drastic as people think basket. And so in the 1960s, as the Senate is considering what will become the 1964 Civil Rights Act, Ervin has already changed his tune dramatically, and he asks Bobby Kennedy, the Attorney General who's before him, he says he doesn't attack Brown in a frontal way, instead he tries to define Brown. He says, this is Ervin to Kennedy, do you not agree with me that denying a school child the right to attend his neighborhood school and transferring him by bus or otherwise to another community for the purpose of racially mixing the school in that other community is a violation of the 14th Amendment as interpreted by the Supreme Court in Brown versus Board of Education? Bobby Kennedy apparently twists in his chair at the time, right, and says, you could make an argument along those lines. And Ervin says with a grin, I don't see how you can disagree with me, right? And over time, in the 1980s, by the time that Ervin writes his memoir, which is called Preserving the Constitution, he says, I re-immersed myself in the Civil War, in the Reconstruction Amendments, and I came to the conclusion that John Marshall Harlan was right in Plessy versus Ferguson, and that our Constitution is colorblind, right? So the modern Supreme Court signs on to this understanding, this anemic understanding of Brown versus Board of Education. In 2007, the court decided a case called Parents Involved, involving voluntary integration programs in Louisville, Kentucky, and Seattle, Washington. School board said, we want to achieve greater amounts of racial integration than would otherwise be possible in light of the residential realities of neighborhoods. And the Supreme Court steps in and says, no, you cannot do that, that in effect, our Constitution is colorblind. The problem in Brown versus Board of Education was that schools were telling students where they could go to school on the basis of their skin, and that's the same fundamental dynamic that is happening here, even though it's in order to promote integration rather than segregation. So rather than viewing the Southern Manifesto as the last gasp of a dying regime, I think it's more appropriate to see it as the first breath of the prevailing order. Thank you very much.
Good afternoon. Thank you so much for having me. I want to thank Mr. Robinson for inviting me here and to have this opportunity to talk about the Southern Manifesto. I just want to quickly say I'm just honored to be on the panel with Professor Day and Professor Driver, and want to kind of extend and really add to some of their comments. So I want to start off by reading a little bit from the Southern Manifesto, since we haven't done that yet, even though we've described it. And this is the portion of the Southern Manifesto, the first part, that every time I read it really kind of catches my attention right away. So it says, when the 14th Amendment was adopted in 1868, there were 37 states of the Union, and every one of the 26 states that had any substantial racial differences among its people either approved the operation of segregated schools already in existence or subsequently established such schools by action of the same lawmaking body which considered the 14th Amendment. As admitted by the Supreme Court in the public schools case, Brown versus Board of Education, the doctrine of separate but equal schools apparently originated in Roberts versus City of Boston in 1849, upholding school segregation against attack as being violative of a state constitutional guarantee of equality. This constitutional doctrine began in the North, not in the South, and it was followed not only in Massachusetts, but in Connecticut, New York, Illinois, Indiana, Michigan, Minnesota, New Jersey, Ohio, Pennsylvania, and other northern states until they, exercising their rights as states through the constitutional processes of local self-government, changed their school system. And in the case of Plessy versus Ferguson in 1896, the Supreme Court expressly declared that under the 14th Amendment, no person was denied any of his rights if the states provided separate but equal facilities. This decision has been followed in many other cases, and it is notable that the Supreme Court, speaking through Chief Justice Taft, a former president of the United States, unanimously declared in 1927 in Lum versus Rice that the separate but equal principle is within the discretion of the state in regulating its public schools and does not conflict with the 14th Amendment. This interpretation, restated time and again, became a part of the life of the people of many of the states and confirmed their habits, customs, traditions, and way of life. It is founded on the elemental humanity and common sense, and for parents should not be deprived by the government of the right to direct the lives and education of their own children. So, as Professor Driver just said, that's a very, I think, eloquent and in many ways a strong case of what I would tell my students is a strong case of legal persuasive writing. So they lay out the precedent as they see it, going all the way back to the origins of the 14th Amendment, and then begin to lay out the case precedent, including Plessy and also Ganglum versus Rice. But it leaves you with the impression, after reading that segment of the Southern Manifesto, that Brown versus Board of Education came out of nowhere in some ways, that it was a constitutional surprise, right? That the Supreme Court departed from what had been the kind of original intent of the 14th Amendment, and they had departed from long-term, long-standing, and not challenged case precedent by deciding in the way that they did in Brown versus Board of Education. So I want to complicate that picture and tell specifically the story of the civil rights lawyers, some of the civil rights lawyers who were associated with Howard University School of Law, and the faculty and the students of Howard that, going back decades before Brown, prepared for the moment of Brown and began building the ability to have that constitutional moment of Brown versus Board of Education. And I think that this is an important part of the story related to the Southern Manifesto, because it shows that over time that the civil rights lawyers really did have to attack what was this long-standing precedent and what many conceived as the unchallenged kind of interpretation of the original meaning of the 14th Amendment. So I'll start off by talking a little bit about Charles Hamilton Houston and the groundwork that they helped lay for Brown versus Board of Education during his tenure as Vice Dean of the Howard University School of Law, which was from 1929 to 1935. So Houston was born to William and Mary Houston in 1895. His childhood was atypical for a black child growing up in the early 20th century. He grew up in a privileged environment. His father was a lawyer who handled civil rights cases for many African Americans in Washington, D.C., and his father also taught at Howard University School of Law. Houston graduated from high school at 15 and enrolled at Amherst College in 1911. At Amherst, Charles Houston began to show the brilliance that distinguished his legal career. He was Phi Beta Kappa and valedictorian of his class, and soon after graduating, he enlisted in the Army and served in Spain during World War I. His service in the Army proved to be a decisive moment in his ideological development. The pervasive racism of the armed forces incensed black soldiers during the war because they fought in the name of their country, and their white counterparts subjected them to racial insults and violence. William Hastie, who was Houston's protege and lifelong friend, said that Houston's wartime experience became a motivating force behind his decision to pursue a law career. So upon returning to the United States after the war, Houston enrolled at Harvard Law School in September of 1919, and at Harvard, Houston gained not only an extensive knowledge of the law, but he also cultivated his obsessive work habits that remained his trademark at Howard Law School and later at the NAACP Legal Defense Fund. Houston was one of the few African Americans who attended Harvard at the time, and the school had a reputation, of course, for both elitism but also discrimination. African Americans and other racial minorities were considered to be tolerated as long as they remained inconspicuous. Returning to Washington the next year, he joined his father's practice, and soon after, he also followed in his father's footsteps by joining the Howard Law faculty in 1924. One of his students described him as tough, combative, and unsentimental, demanding excellence of himself and his students and his professional colleagues. He was affectionately known, or not so affectionately known, as Iron Shoes, sometimes also called Iron Pants. And so for all of you professors, teachers in the audience, that I consider that a high compliment for a student to give you a nickname like that. In a 1920 speech, Houston explained that a good trial lawyer must have knowledge of the law, knowledge of human nature, courtesy, poise, sincerity, honesty, tenacity, and unshakable equilibrium. So he believed that for black lawyers who were going to have the responsibility of using law to better the conditions of their community, instilling the importance of questioning the law was crucial. It was not enough for them to accept and uphold current law as officers of the court, because in most places at the time, the state laws themselves were means of actively oppressing black Americans. So in order to reach their goal, he felt that his students, who he called social engineers, had to start from what should be the basis of all United States law, the federal Constitution, and find in it the means for breaking down Jim Crow and any other legally enforced segregation. So in terms of the actual work that they did at Howard Law School, in 1931, Houston recommended that Nathan Margold, a Harvard graduate and former assistant United States attorney, develop a report for the Garland Fund, which was established in 1922 to develop a legal strategy to end segregation in the public schools. The Margold report of 1931 set up a two-pronged strategy to attack separate and two-pronged strategy to attack separate and unequal schools. This strategy later became the basis for Brown versus Board of Education. Houston's influence on actual civil rights litigation increased when he left Howard in 1935 to become the chief legal counsel for the NAACP Legal Defense Fund, and he argued the case of Missouri ex rel. Gaines in 1938. So in Gaines, Lloyd Gaines applied for admission to the University of Missouri Law School. He was denied admission. They filed suit under the 14th Amendment, arguing that he was denied equal protection of the law on the basis that Missouri only had one opportunity for legal education in the public sector, and that was at the University of Missouri Law School. So the theory at the time was to enforce Plessy, to enforce the separate but equal principle, and they won in the Supreme Court. So this Missouri ex rel. Versus Gaines is thought of as really the first kind of push of the door open to Brown versus Board of Education, and the idea was that first, they had to establish that there had to be an equal standard. University of Missouri could not establish that there was any equivalent in Missouri, and so they prevailed in the Missouri versus ex rel. Gaines case. Of course, that case was very tragic because Lloyd Gaines, who was the plaintiff, disappeared and never was heard from again after the decision by the Supreme Court. Of course, Thurgood Marshall succeeded Houston as the head of the Legal Defense Fund, and one of their crowning achievements, of course, was the Sweat versus Painter case in 1950, which ended segregation in American law schools. And so they were able to establish that you could not have a separate but equal principle in the law school environment, because law schools are more than books, more than buildings, et cetera, but the ability to be able to interact with other students. So the strategy that the NAACP Legal Defense Fund used in this case stemmed directly from the education that Charles Houston and other faculty provided at Howard. The first evidence of this is the fact that Sweatt was selected for litigation at all. Their theory was to use legal education as the test cases because they believed that the Supreme Court justices and other judges would relate more to the idea of what was inherently unequal about having separate legal educational facilities. So I think the history of Howard's Law School and of Charles Houston and the process of the civil rights litigation demonstrate that Brown was not a surprise, right? So it took a long time, a long process of developing legal theory, of training lawyers who would be able to actually litigate these cases. In response to the Southern Manifesto, Thurgood Marshall's response was that he pledged the entire $250,000 annual budget of the LDF to be able to file individual cases in all school districts throughout the South. He recognized, as Professor Driver said, that what the Southern Manifesto did was really set up what the terms of the debate would be. It meant that this would be a very gradual process, so they would have to fight on every front to individually desegregate the various school districts. Thank you so much.
So I'll address the first question to Dr. Day. Other two can jump in if you like. So in reading your book, two things came to mind, and you mentioned one here about nullification and interposition. And these were not terms, these were terms we had not heard in a very long time. We know they had something to do with what Thomas Jefferson had written regarding sedition and alien sedition acts. Why were those two terms so important within the national context of politics, in the mid-50s? And how do you think in particular that shaped the Southern Manifesto's language?
The term interposition kind of arises in the early 1950s by a journalist by the name of James J. Kilpatrick, who was working at the Richmond Dispatch. He was protege of the famous biographer of Lee and of Washington and so forth. And he wrote a series of articles in the Richmond Inquirer, I think it was, that kind of outlined resurrected this idea about interposition that supposedly, resurrecting some of Calhoun's language in the nullification debates, and then going back to the Kentucky and Virginia resolutions, and really twisting those. If you ever read the Kentucky and Virginia resolutions, they're one of the great defenses of civil liberties ever written in American constitutional law. But Kilpatrick, not a lawyer, graduate of my own alma mater, University of Missouri J School, he just thought up this idea that states had the right to interpose themselves, what he called interpose themselves between the federal government and their citizens when a constitutional dispute was in question. And Harry Flood Byrd of Virginia and the Virginia legislature really took this up. And then later, Governor Marvin Griffin of Georgia took this up, and then it spread to Mississippi. And they actually, the governor of Virginia at the time called a number of Southern governors to the governor's mansion in Virginia, and they had a parley in which they declared that yes, they did have the right to interpose their governments and but essentially nullify the Brown decision within their borders. And by December of 1956, you have Virginia, South Carolina, Alabama, Mississippi, and then later Louisiana, 5 states who, in some shape or fashion, officially declared Brown null and void within their borders. Other states followed suit. North Carolina, under Luther Hodges, later be Kennedy's Secretary of Labor, and then Arkansas, as well as some others. What they try to do is what they said, well, this is a little local issue. We'll let local school districts decide whether they want to integrate or not, which essentially meant that they shirked any legal responsibility for the right to enforce a federal law. They essentially, by saying that this is a local issue and we have to worry about sensitivities and so forth, essentially just ignored the Brown decision. They were, I think, intelligent enough to know that if they went ahead and declared that, I think as my colleagues are saying, if they use that inflammatory language, that would draw attention. So in most of the former states of the Confederacy, in some shape or fashion, you had the state governments officially saying that we will not comply with the Brown decision. And the Southern Manifesto is essentially an expression of that and gives them the legal cover in which to essentially ignore the decision, I argue, until 1969 with Holmes v. Virginia.
Okay. So, Professor Driver, you mentioned the idea of the North. And in fact, before I read your article, I didn't really look at the Southern Manifesto as being a nod and message to the North. We know as lawyers, semantics matter a lot, and so do semiotics. And so talk a little bit more about the Southern Manifesto, particularly what they chose to avoid. Because in many ways, when I read the Southern Manifesto, or the Declaration of Constitutional Principles, was that a play on the Declaration of Independence? And then I looked at some of the language from the southern states that, Dr. Day just mentioned. Sounds kind of familiar to the states when they decided to secede. How does that play into this?
Yeah. So the document is written in a way so as to avoid the most inflammatory racial rhetoric of the era, even that was used by people who were regarded not as extremists, but as mainstream defenders of segregation. There was a playbook, in effect, that talked about the sort of, the certain moves that one would use, and they don't use that. And that's part of the reason that one knows that this is not, as some have suggested, this document is not designed to whip up segregationist sentiment in the South. There is a steady playbook that one could draw upon if one wanted to do that. And you would talk about miscegenation, right? Our daughters are going to go to school with these big overgrown Negroes, right? This is the type of language that people would have used in order to whip up segregationist sentiment in the South. And instead, they are trying to speak to the North and trying to come across as, I think, reasonable and calm. And these are sophisticated politicians who are capable of speaking in different registers when they are with different audiences as well, right? And so that's an important thing to say. So I say overwhelmingly the document consists of legal arguments. Some offensive racial rhetoric did manage to creep into this document. And it was understood even at the time, although overwhelmingly people said that this is a calm and moderate document. But one of the things that did strike me at the time, it says, this unwarranted exercise of power by the court is creating chaos and confusion in the states principally affected. And here's the relevant part. It is destroying the amicable relations between the white and Negro races that have been created through 90 years of patient effort by the good people of both races. It has planted hatred and suspicion where there has been heretofore friendship and understanding, right? So we had a really good thing going here until Brown versus Board of Education came along, black and white, well, not quite together, but, generally on the same team. And this speaks about the mindset of white supremacy at the time, that people could not believe that what they would refer to as, our Negroes want racial equality. In fact, it is a cliche at the time. White people would say, black people don't want integration. I asked my cook, and she told me that they didn't want it at all. And so that was, they just couldn't believe that these people really wanted this. And so, but the marvel of the Southern Manifesto is not that managed to creep in, but that so much else managed to stay out.
Point. So the dean mentioned that the strategy to attack Jim Crow began years before, and Howard played a strong role in that. We often hear the term social engineer. How did that term social engineer, how did it play out into creating lawyers, and how did they play a role in the southern states and, again, in untangling Jim Crow?
So Charles Hamilton Houston famously said that a lawyer is either a social engineer or a parasite on society. And when people asked him, what does the term social engineer mean? He said that a social engineer is a lawyer who knows what the community needs, knows what the Constitution means, and is able to, through their knowledge of the law, basically change the world around them. And I think that principle, the idea that these students were in school, so students like Thurgood Marshall and Oliver Hill and others, that they were there with a sense of urgency, right? So a sense of urgency that their legal degrees, the law that they were learning, even though the curriculum at Howard was very standard for the time. Houston pretty much incorporated all of the curriculum that he had at Harvard. He pretty much brought to Howard with him. One of the biggest things that happened at Howard at the time is it became accredited by the ABA, which was unheard of for a African American law school, of course, to be accredited by the ABA. Not very many law schools at all were accredited by the ABA at the time. And so the teaching was a very traditional teaching. So if you go back and look at what he taught in administrative law or what they were teaching in contracts, it was very standard for what you would see at most law schools at the time. The difference was that they also were actively involved in litigation. So for example, in Missouri ex rel Gaines, Houston argued that case in front of the Supreme Court. He argued a moot the day before at Howard's Law School with all of the students, the faculty there, and they said he went directly from his office at Howard to the Supreme Court to make the argument, walking from what is the main campus of Howard now to the Supreme Court, a very long walk. I said he had a lot of time to think, to make that argument. And so that kind of idea that this was a laboratory, right, that it was a place that you weren't there in school just for yourself to get your own degree, but the work that they would be expected to do was work that would transform the Constitution, which it eventually did. So it was a long road, but I think that idea that that was the project that they were engaged in was one that was at the forefront of their minds and was very openly talked about, discussed, and pressed upon the students that they were in the process of transforming our democracy.
So all of you, and this is a question for anyone who wants to jump in, all of you have mentioned Brown. So we know it's Brown 1, 54, Brown 2, 55. Now we've got the Southern Manifesto. Two-pronged question. Number one, how dangerous in 1956 is the Southern Manifesto in terms of looking to the future? Is this really going to create the kind of society we want or not? And then number two, how do some of the lawmakers or politicians use this as what I would call a policy entrepreneur? How do they take this and then say, you know what, I'm going to do something different and move ahead? We'll start with you and then move forward.
Well, regarding danger, it's a big kind of interpretation about the civil rights movement in general. Okay. Michael Klarman's a big proponent of this, what's kind of known as a backlash thesis today. But what I argue in my book is that essentially the Southern Manifesto produces what I call a moderate consensus towards the civil rights struggle. And again, what my colleagues have been mentioning, most of the senior leadership within the Southern Caucus, particularly Richard Russell and others, understood that acts of violence and the rabble-rousing you saw with the Arthur and Lucy riots and so forth, that was what they believed was the worst thing that could happen, would only provoke federal intervention and he's a very cagey politician. He kept up with the debates of the NAACP. He kept up with the you look at his papers. He kept up daily with the Montgomery bus boycott and the Arthur and Lucy riots. Very much had his finger on the pulse of political opinion throughout the nation in the late 1950s, and he knew that I would say with the Selma protests in 1965, which draws federal intervention, Russell understood how politics worked in this country. For example, during the debates of the 1957 Civil Rights Acts, in which J. Strom Thurmond launches his infamous 24-hour filibuster. I talked with Russell's biographer, Gilbert Fite, and he pointed out that actually Thurman launched that filibuster after the final version of the bill was negotiated in the Senate. And Russell was so mad at Thurman for doing that. And believed that just made the Southern Caucus and it made the segregationist argument just look foolish. That it was just grandstanding and would only draw further attention to the iniquities of Jim Crow. After looking at both their papers, I'm pretty much of the opinion that Thurman and Russell despised one another and the way they approached this issue, even though they were ideologically similar. I think for them tactics was very important. And Thurman producing something like the Southern Manifesto had to have the imprimatur of legitimacy. And if someone, rabble rousers like Eastland, who was traveling throughout the South, encouraging school districts to defy Brown, or Thurman with his overt race baiting, as you see in the 1950 Senate campaign in South Carolina, for Russell, that was the wrong strategy to preserve Jim Crow.
Yeah, I agree with Professor Day that much of our thinking today comes through the idea that segregationists were intentionally sort of whipping up their constituents into a frenzy and sort of were in effect winking when they say here, we don't want any lawlessness or disorder. But exactly as Professor Day suggests, there are statements at the time from Senator Ellender of Louisiana and others saying, right, if there are acts of violence, it's going to retard our goal of preserving segregation. We need to win in the court of public opinion for the North. And so they are identifying with precision what ultimately unfolds. And so I think it's probably inaccurate, at least those who are saying, if there are acts of violence in the name of segregation, it's going to hurt our cause, to view them as being dishonest or talking out of both sides of their mouth, in the sense that, again, they identify the negative consequences that they believe will flow from that. I think it's also worth thinking about the way that the Southern Manifesto elicited an important debate in Congress about notions of judicial supremacy. Who's responsible for interpreting the Constitution of the United States? Is it legitimate to have this document that comes out and looks a lot like a legal decision itself? Indeed, critics might say that the Southern Manifesto is a lot more legal and legally grounded than the Brown versus Board of Education decision. So is this a legitimate thing? There was an extensive debate, and I looked at the debates in Congress about how they were thinking about the court's role versus the ability of other elected officials, and overwhelmingly they were saying they wanted a reversal of Brown. This was not meant to be a binding opinion, but they were trying to court, again, public opinion in order to, because that's what they believe the lawyers for the NAACP did so effectively, right? Thurman says that this was an exercise in propaganda, and if propaganda can give desegregation, it can also save segregation. And so it's also important, I suppose, to think about the Cooper versus Aaron decision and the whole controversy around Little Rock, Arkansas in 1957. I think that one of the reasons that people believe even more today than they did in the 1950s about the Supreme Court is having the decisive role in matters of constitutional interpretation is attributable to the unforgettable images of President Eisenhower sending in the federal troops into Little Rock. Because we've seen instances where people say, I'm going to decide what the Constitution means, I'm not going to listen to these courts, and the results are ugly. So just as Brown is sort of bedrock and foundational, it seems to me that Cooper versus Aaron has also become bedrock and foundational, and people are going to be very hesitant when others make claims on the Constitution, including relatively mild statements, like when President Obama said, in effect, I believe that the Supreme Court of the United States believes in judicial restraint, and they're going to not invalidate my signature healthcare legislation. People were up in arms about this. Is this a legitimate thing? Is he trying to work the referees here? This is its own separate sphere. So that's a testament to how far we are at worshiping at the altar of judicial supremacy.
I think if you think of the Southern Manifesto as as propaganda, as an attempt to really slow down what was going to happen in Brown, what was going to happen in the aftermath of Brown, or reverse Brown, I think it can be said that it was very successful in the sense that we didn't see for a long time any real movement in terms of integration in the schools. I'll give you a few statistics. These are from the UCLA's Civil Rights Project. There was, until 1968, there were only 13.9% of black students who went to majority white schools. So you're talking about an entire decade in which basically nothing happened. And then after the high point really came in 1988, when there were 43.5% of black students who attended white schools. So eventually the project took off, but it didn't take off without a lot more work from the Supreme Court and really kind of attention to the detail of the individual school districts and how to work on desegregation in those individual school districts. But in terms of a kind of shot across the bow, we will not allow this decision to take hold, I would think 10 years of basically preventing almost any integration from happening would be considered a political victory in almost any way you can interpret it.
Sure. One general question before we go to Q&A. So we've got an idea of what members of Congress have said. We've got an idea what some lawyers have said. From your research, what were some black lawmakers or black superintendents or lawyers, what was their response during this time?
Well, I would argue that, generally speaking, the vast majority of African Americans in this country are certainly in favor of desegregation. Now, we have to remember, though, that particularly in the South, at historically black colleges and universities, college presidents and faculty are really in a bind because they are subject to the whims of state legislatures and state appropriations. And you see the presidents and chancellors of historically black universities, particularly at state schools and so forth, very much a cautionary tale. And you see, of course, you see this play out in the early 1960s, in which a lot of their students start engaging in protests and so forth, and some of them are expelled, some of them are suspended, and that a lot of college presidents kind of distance themselves initially from those protests because they have cultivated relationships for years under the Jim Crow era of getting state appropriations. So it's relatively mixed. Though in the national press, in the national press, you see like the Chicago Defender and the Memphis Defender and the St. Louis American and so forth. They are overwhelmingly condemning of the Southern Manifesto, and of course, is I guess the Chicago Defender who calls the Brown decision the greatest victory for African Americans since the Emancipation Proclamation. It's African Americans always really identified with Brown as the integral decision of the 20th century.
Yeah, there is some evidence where we have congressmen sort of patting themselves on the back saying it's wonderful that we sent out this statement and it has been effective. And so then I think you're acting exactly the right question, which was Woodward's response in the civil rights community. And the civil rights community was deeply concerned that this was going to be effective. A. Philip Randolph of the Brotherhood of Sleeping Car Porters writes a letter to other leaders, including Roy Wilkins of the NAACP, and he says, this document is going to tamp down integrationist sentiment in the North, and he sends a couple of different letters where he directly mentions the Southern Manifesto as being a grave cause for concern, where he is surveying the response among mainstream newspapers, and he says you can already tell that it is diminishing any enthusiasm for this, and we're going to have a long slog. And Carl Rowan writes a book right around this time where he says exactly the same thing. So I'm in agreement with Dean Holly Walker. He says that it seems like this was an awfully effective statement at gathering an enormous amount of attention and giving people pause before they rushed headlong into integration.
I think with Thurgood Marshall, I think his response, it's interesting to see that they saw the Southern Manifesto together. He saw the Southern Manifesto together with Brown 2 and the language related to all deliberate speed, that those two things, he clearly said, are an indication that Brown will be about gradualism. That gradualism is now the theme of Brown versus Board of Education and is something that we will have to confront directly. So there's lots of kind of arguments within the civil rights litigating community about what to do in the face of that, and I think their strategy becomes very clear, but it takes an all-front, very expensive resources, both manpower and also monetary resources, in order to be able to fight the kind of fight that you need to once you have Brown 2 and also the Southern Manifesto, and you see the kind of political wins in after Brown. I think that really shapes a lot of what happens in the desegregation litigation, and may be an indication of why, even now when we still have pending desegregation cases, why we have so many challenges in that area, because of this kind of individualized district by district litigation strategy that they were forced to go on because of Brown 2 and also because of things like the Southern Manifesto. So it had really long-term effects that can be seen all the way to parents involved, where this is a continuous argument. So whereas you can think of things like when you think of the marriage cases, so Loving versus Virginia, if you're talking about people issuing marriage licenses, that's not an ongoing legal battle. It could be, but it's not an ongoing legal battle that you have to fight in many states, various, in every clerk's office that issues marriage licenses, where this turns into a literal like tobacco litigation or any other form of kind of broad litigation. This turns into a long-term, decades-long individual district by district litigation fight.
Very good. So you've heard the three speakers. Everyone up here has mentioned Brown v. Board at some point. We know that later tonight we're going to have an opportunity to hear from Cheryl Brown Henderson, who's in the audience right now. We'll hear from her later. Professor Driver happened to mention Briggs v. Elliott, and it's worth noting that Mr. Nathaniel Briggs is actually in the audience sitting at the table here, and we also have Deanna Stooks Hightower, also from Briggs v. Elliott, who's here as well. And so as we have a conversation about the Southern Manifesto and Brown, the people here today were children at that time, and it was worth making sure they were here for the discussion. There's others that I will introduce when we move forward to the next panel, particularly to talk about Virginia, because we have some of the Virginia delegation here as well. So what I'm going to do is we've got mics here. What we'd like you to do again is to state your name, affiliation, and ask a question. We will have someone here and someone with a mic. We see a hand in the middle, so we'll start here in the middle, and then we'll move to different sides. Two here. So we'll get you two, and then we'll move over to my right.
One and the other. Okay. My name is Joe Freeman. For purposes of this question, the relevant background is that I spent 4 years in the civil rights movement, including a year and a half working for the Southern Christian Leadership Conference doing voter registration in 65, 66. And I'm writing a book about it. Okay. I would like to ask if the Southern Manifesto was perhaps a strategic mistake. And my basis for that question is when Briggs v. Elliott went back to the three-judge court which decided it, and they had to issue a new opinion in light of Brown, they said that the court does not impose any obligation to mix persons of different races in the schools. It merely forbids the use of government power to enforce segregation. Now, think for a moment, if the Southern Manifesto had not been issued, had not generated all that publicity, would not deference for a judicial body have allowed this perspective to become the pervasive, applicable perspective without a strong reaction against it? I mean, it was presidential in the Fourth Circuit and advisory in the other circuits. So was the Southern Manifesto a strategic mistake?
Whoever wants to take it.
It's a very good question. I would happen to say, at least, I would argue maybe not. You mentioned the Gallup poll in 1959. The Gallup poll I saw right after Brown showed that overwhelmingly a majority of Americans actually favored the Brown decision. I may be arguing a case too much, but I think that the Southern Manifesto really takes the wind out of those sails. I see a lot of optimism in the wake of the Montgomery bus boycott, and so forth, and the idea, a lot of optimism, particularly in the African American community, and I would, and in my book, I really try to make a point that. When so-called Southern moderates, overwhelmingly the majority of the Southern congressional delegation are veterans of the New Deal and came up through the New Deal and the massive expansive government and the creation of the modern welfare state during the Great Depression. And people like John Sparkman and J. William Fulbright, Spencer Holland, Brooks Hayes, all had really national representation. National reputations and national constituencies, very strong leaders within the Democratic Party, and so forth. That after the Southern Manifesto, the Kefauver, Essex Kefauver abandons his civil rights, his enforcement of Brown. Governor Adlai Stevenson, the Democratic Party does not endorse the Brown decision, I really think that Harry Truman's Fair Deal is very much rejected by the National Democratic Party in 1956, and I think that turns on that document that very much kind of and this is always counterfactual history, and I try to do this with my students, is a great what if. What if both national parties had endorsed Brown? What if Senator Lyndon Johnson and Sam Rayburn did not table what becomes the 1957 Civil Rights Act? Carrie McWilliams at The Nation was saying, the Brown decision, and everyone's saying, let's take the Brown decision out of politics, let's take the court out of politics. Carrie McWilliams of The Nation says, no, the Brown decision is not political enough. Let's make it the salient issue of the 1956 election. You get that momentum, and that would have been, I think, a different case.
Yeah, just quickly, there was some internal debate among Southern elected officials as to whether this was the most sort of efficacious way about going about defending segregation. So some people who declined to sign the Southern Manifesto said, it's not that I am an integrationist, it's just not going to be helpful to, in effect, howl at the moon about the problems of integration. And so there was some sort of internal disagreement. Lots of people in Texas in the House of Representatives didn't sign. But I think it's hard to think of it as a strategic misstep because they were working that is to say, the people who drafted the Southern Manifesto were attuned to what Judge Parker had written and, in effect, would subsequently adopt what he said as their own understanding of Brown in order to defang the opinion from their perspective. So, I don't think it was a strategic misstep from that vantage point.
See a hand here.
Excuse me.
No, I'm going.
I'm sorry.
I'm going to this side and then back there.
Oh, sure.
Yep. We'll come back.
Thanks.
Hi, my name is Joan Johns Cobbs, and John Stokes and I were plaintiffs in the 1954 Supreme Court decision, Brown versus Board. And as far as the Southern Manifesto, it is my opinion that that document had something to do with the closing of the schools in Prince Edward County, Virginia from 1959 to 1964. That is my opinion. I just wondered if anyone else wanted to speak on that.
Some of you know Dr. Amy Tillerson. She's going to come on our second panel, and I'll make sure, I don't know if she's here now, I'll make sure she addresses that. Does anyone want to address that right now?
I would tend to agree with that. Remember in 1956, Governor Alan Shivers of Texas uses Texas Rangers to prevent federal desegregation orders in Mansfield. The next year after Eisenhower is elected to a second term, Faubus tries the same thing and has very different results. Remember, the Democrats come roaring back in 1958 when both gains large majorities in both houses of Congress. Orville Faubus is voted one of the 10 most admired men in the country after Little Rock. And I think Eisenhower's use of troops was very unpopular, and not only in the South, it really trimmed the sails of his efforts to try to create a two-party system in the South. And I think that after that, Virginia is able to have the political cover to do some of the things because of the reaction against Little Rock. So.
One thing that was mentioned, you give it to him, Bobby Kennedy's name was mentioned when he once said that there are three places on earth where there's no democracy: Russia, China, and Prince Edward County at the time they closed the schools. Yes.
Thank you. I'm very glad you went to this lovely lady first. But my question is a quick observation. I am the executive director of the Rural School and Community Trust. My name is Robert Mahaffey. We advocate on behalf of all the rural children across our country, particularly those that are marginalized, living in poverty and in remote areas. A few years back, I read Professor Henry Louis Gates' memoir, Colored People. And he grew up during this period of time in Piedmont, West Virginia, a rural community in a valley. And I actually visited that community. So building on this line of observation about superintendents, black people, and what about the families? Because in Piedmont during that period of time, Gates makes it very clear that there was no rush to try and integrate the schools. I mean, people felt very comfortable across racial lines. So it sort of picks up on your observations, and I'd be very interested to know what you think about young people who were in schools and their families. Thank you.
We've got a couple of minutes before we move to the panel, so any of you can take that.
And I think we'll hear tonight from someone who can speak more directly to that. But I will say that the danger, I think, to the families who became plaintiffs in these litigations, this was not going to happen overnight, and this was significantly resisted. So it wasn't, I think, the idea that they did not seek or want integration, but I think the idea of what it took to get there. This was not people throwing open the doors and saying, please come in, but this took litigation. It put the lawyers in danger. It put the families in danger. And the idea of the sacrifice that it would take in order to make Brown be able to be alive on the ground in all of these communities was something I think that Black communities were very, very aware of, the cost, the price, the sacrifice that it would take. And so I think it's not I don't agree with the statement that they did not want or were not passionate about the idea that they could manifest all of their civil rights, but I think the idea of what needed to happen to have that occur was something that people were very, had a good idea of what that would take. And it was not an easy thing.
Well, this is panel one. As you see, we've started a robust discussion. Our scholars are actually going to remain with us, and so there'll be more dialogue. Make sure you save your questions. I want to thank all three of our scholars for being here today. I think they gave us a great insight.
Thank you all very much.
Into the Southern Manifesto, the law, the language, and the past. And now we're going to transition to panel two, where we're going to talk about the stories and the states. So thank you for your time.
Thanks.
Thank you.
Good job.
Yeah.
Thank you.
Yes.
Yeah, very much. Thanks, Dean.
Thank you. That was wonderful. I'm looking forward to reading your book.
Thank you. Thank you very much. Good stuff. It's quite an honor being here.
Oh, glad to be here.
And with
I mean, this is incredible.
In fact, when Justin said
I've never
Briggs,
met the Briggs.
Yeah. In fact, I talked to him on dinner last night. Did one-on-one. And so when the driver mentioned, I went, yeah, I'm gonna have to mention that. If you get a question from the heavy table, you better be ready. Right. That's Amy Tiller. Her mom was actually involved as part of the school pool when students walked out. So she's gonna talk about that.
Yeah, that's incredible.
Good to see you. Good to see you. Good. Right. Well, that's the heavy table.
Bravery,
So,
yes. Yes.
so if you see a hand raised,
Yes.
you're ready.
Yeah, I know.
Well, I'm glad you're here. It's a great group.
Oh, thank you. Thank you. Yeah. It's only been, I think, almost 2 years.
It takes a while to adjust, I'm sure.
Oh my gosh, it definitely does. It definitely does, especially.
All right. We're going to begin in 4 minutes. Yes. I'll make the intro quick. And your sheet helps. Oh, okay. Oh, of course you did. Hey, bro. Thank you, good man.
Yeah. So, what do you think? What's going to contribute?
Talking about that because they played a little role in this and say, and then go into sugar. So you give some of these people quick love.
Yeah, that's
and
what I'm
then
going to do.
your stuff in the
Well, yeah, with the quick presentation I did, it was history of SRE,
Yep.
right? Just like you said, and then I go right into the future, where I am in Georgia, and flexibility.
Got it. All right.
And then, if we have time, ending with that.
All right. If we can get our panelists up to their seat. And where are you sitting?
I'm all the way down at the end, but I'm just so I could talk from up here, so I can.
Oh, that's fine.
Thought my back right to the.
Okay, so you'll come up afterward? Okay, that'll work. I'll introduce you guys and we'll go. You're first and Amy second. Could you get Amy The African American woman in the corner. Get her. Yeah. Okay, we're getting ready to begin, and we can have all speakers come and take their seat. Wearing. I had to think about I never called him that.
Yeah, I know, you never say it out loud, right? Like,
I have to go fast.
He's moving up because he can't see, but if all of you want to stay here, that's fine. If not,
okay.
I'm gonna come back here when I'm done.
Yeah, whatever.
All right, we'd like to have everyone go ahead and take their seat.
Yeah, thanks. Hi, I'm Amy Tillerson Brown.
Robbie Luckett.
Well, good to meet you.
Good to see you.
Okay, I'd like to welcome you back for the second portion of our panel. I'm going to begin by introducing our speakers. This session, we're going to focus on the Southern Manifesto and state education policy. All of this took place at the state level, as we heard from the first panel, and we're going to talk about states. We're first going to get a big overview, and we're going to hear from Dr. Stuart Buck, who is Vice President for Research Integrity at the Laura and John Arnold Foundation in Houston, Texas. He's got a JD PhD and was interested enough in this subject that he decided to write a book, and it's called Acting White, The Ironic Legacy of Desegregation, which was published by Yale University in 2011. Second speaker is going to be Dr. Amy Tillerson, who's a professor at Mary Baldwin College. We had a chance to meet during my time in Virginia. She is a scholar on particularly Prince Edward County, a school system that was mentioned earlier, one of the 5 in the Brown v. Board of Education case, and she's going to talk to us about Virginia. We've got Dr. Robert Luckett, who is a professor at Jackson State University, Mississippi, also directs the Margaret Walker Center for African American Experience. He's the author of Joe T. Patterson, his book on the dilemma of the white South, evolving resistance and black advancement. Mississippi played a tremendous role one way or another as related to the Southern Manifesto and its aftermath, and so he's going to tell us about the story in Mississippi. And then we're going to hear the story about Georgia from Dr. Eric Wern. He's a professor at Georgia Gwinnett College. Eric and I had a chance to work many years ago on school choice movement in Georgia. He also works for a former governor, and so he's able to blend history, academics, and politics quite well, and Georgia has a very unique story. So I will invite Dr. Buck to the podium, and we will begin panel 2. Thank you.
Thanks for the introduction. So I thought I would start with a quick story about why I got interested in this subject in the first place, because it might seem kind of unusual. So rewind to 2004. My wife and I, we already had 2 kids of our own. We decided to adopt, and we ended up adopting a little a boy who had just been born who's African American. And not to give any secrets, but we're white. And so I started realizing, okay, I need to figure out a lot of issues. I mean, I'd been interested in race and law. I took a course on race relations with Randall Kennedy at Harvard Law School. But now it was getting personal, right? I need to figure out, okay, how are we going to navigate this kind of interracial family that we now have? And started reading about interracial adoption and education in the African American community. And right about the same time, it was the 50th anniversary of Brown v. Board. And I read this, just stumbled across in my local newspaper, this fascinating article that presented a kind of contrarian view from some scholars like Vanessa Siddle-Walker and others, pointing out that in some cases there had been an unfortunate legacy of basically the destruction of black schools and black institutions and the way that desegregation plans were often carried out. And so I started, this was all just kind of rumbling in my mind, and I started thinking, okay, what if the placement of black students in white-controlled institutions, controlled by white supremacists at the time, what if that contributed to a feeling of alienation from education that sometimes we see even to the present day? And so one thing led to another, and I ended up writing a book. And so to make a long story short, the broad overview is that there's an achievement gap in K through 12 education today. And I argue in the book that part of this absolutely not all of it, and I go into the fact there are many other reasons, but part of it might be due to a feeling of alienation from school, or what some have deemed the acting white phenomenon. And there are a number of studies on this, everyone from just people that you talk to President Obama and his wife, Michelle, have spoken of the feeling that they were sometimes accused of acting white in schools for taking too much interest in academics or for the way that they were speaking. And I argue in the book that this feeling can be traced to an unfortunate side effect of how desegregation was carried out in the wake of the Southern Manifesto. It's not to say at all that desegregation was a bad idea, but desegregation was not carried out by Earl Warren riding into town on a horse and setting everything to rights like John Wayne and then leaving into the sunset as everybody lived happily ever after. It was carried out by the same white supremacist school boards who were electing people that would write things like the Southern Manifesto. And the way that they carried out desegregation was often to the detriment of the black institutions that have been created. And so I'll give some examples of that. And so my overall conclusion is that the way desegregation happened has lessons for how we should pursue integration today or in all walks of life. So just really briefly on the acting white phenomenon, there's a scholar at Harvard, Roland Fryer, who found a unique data set where people in schools, students in schools, basically were asked to rank their friends. And he found out that, unfortunately, especially in integrated schools, that the high achievers amongst African Americans suffered a popularity penalty. They were not ranked as often as being friends by their classmates. And he found out that black males suffered the worst. They were, quote, penalized 7 times as harshly as my estimate of the average effect of acting white on all black students. So acting white is his term for just this drop in popularity for black students that are doing particularly well in school. And there are lots of other studies on acting white that find it mostly in integrated schools, which is also interesting. And in fact, the very first academic study that brought the phenomenon to attention was a 1970 book about a desegregated school. And in that particular school, there were a few black students who were they'd set up a sort of tracking system where the white students were in the advanced class, and then there were a few black students who were allowed in, and the black students found themselves kind of caught in the middle between, wanting to be in the advanced class, but then at the same time accused of leaving their community by doing so. So just to take, I know this is generalizing over hundreds of years of history in about a 1-minute period, but so I go into more depth in the book. So the interesting thing that I found was that prior to desegregation, prior to the 60s, I couldn't find any evidence of this sort of acting white or sort of alienation from school. To the contrary, history is replete with stories, just heartwarming, touching, poignant stories of people in the most desperate and dire and oppressive of circumstances in the wake of slavery and Jim Crow coming together to build a school and to pursue education at all costs. And so this picture is of a rally held in Louisiana about 100 years ago to build a school, to gather the money to build a school. And at the time in black schools, there were lots of cultural events such as May Day celebrations that were very common. There are many anecdotes and tales from the time about the centrality of the black teacher and the black principal, and about how much they were served as role models and tried to encourage success in all walks of life, and particularly in terms of academics. And the unfortunate thing, though, is that all of this kind of disappeared, and that might be an overstatement, but with desegregation, we saw the large-scale elimination of black schools and principals. And just to give you a few facts and figures, so in North Carolina, there were 226 black schools in 1964 and 226 black principals. As of 8 years later, there were 13 black schools in North Carolina, the historically black schools, and 15 of the black principals remained just a few years later. In Topeka, Kansas, the 4 historically black schools were closed. Most of the black schools in Arkansas were closed. In Oklahoma, all but 3 of the 94 historically black schools were closed. Virtually all of the schools in Delaware were closed. As for black principals in particular, which they had served as a kind of role model in the community, there were 1,424 black principals that were counted in one particular survey in the 1960s. That number dropped to 225 total in 1970. So the integration often was carried out by destroying the black school and demoting or firing the black principal. And even when the black schools remained open, there was a report in 1970 that said that out of 321 black schools that were themselves integrated and remained open, 188 had their names changed, so over half. The trophies and mascots often were thrown away. In some cases, the white school boards decided to replace all the toilets and fumigate the schools on the notion that they had to be cleansed before they could allow white kids to go into the schools. So here's a particular example, and this was just a heartbreaking picture when I first came across it. This was taken in Charlotte, and these are three boys watching as the Second Ward School, the first black high school in Charlotte, is being demolished pursuant to a desegregation plan in Charlotte. And the people there just found that it was just heartbreaking. There was a graduate of the school at the time who said that she said, "I don't advocate segregated schools today, but there are attributes of that time that need to be in place today. Our teachers, they look at you almost as if they were wanting to will a good education into your head." But when the school was demolished, as you see there, the students were devastated. One person said, "An institution was being closed. It was heartbreaking, it really was." Another person said, "We thought that was the utmost in betrayal." And then someone else said, a former teacher said that she still kept in contact with her former students, and they would just call her up and cry about the situation that they had been thrust into with their school being destroyed. And this kind of situation happened in a wide variety of communities across the South because, as I said, it was white-dominated school boards that were carrying this out, and usually the last thing they were going to do was destroy the white school and send the kids off to the black school. So it often happened, to the disadvantage of the black kids and the black principals and often the black teachers who had, for better for worse, built up a cultural institution in which academics were highly valued. And in fact, there were over a dozen cases that I found that I was actually astonished by, where there were black-led protests against desegregation plans. So this is Hyde County, North Carolina, and you see they're carrying signs that say "Save Black Schools" in Hyde County, because the desegregation plan there involved demolishing the black schools and breaking up all the classrooms and sending the black kids across to the white schools. And so the community there came together and protested. In fact, there was a similar protest over a high school in the Atlanta area that also was destined to be closed. And as I did often throughout writing this book, I tracked down the person who had led the protests and been on the front lines. And I talked to him, and he said, and he was just like bitter when he was talking about this. He said, what led me was that had been the hub of our community, our schools and our churches. It was an everyday thing, generating unity and brotherhood and sisterhood. I was willing to fight for that. That school that led us and nurtured us, you're just going to close that off and tell us without any explanation, okay, there's not enough Caucasian kids going to your school, so we're going to close you down. So he led protests in Atlanta over that. So what also happened with desegregation, and possibly cherry picking some of the worst examples, is that kids were often thrust into a very hostile and unwelcome environment. So that's some kids protesting in Tennessee. There you see some of the Little Rock Nine being led in by the 101st Airborne in 1957 in Little Rock. There you see one unfortunate kid who was on the front lines desegregating a school in Virginia. You can see he's not exactly a welcomed and valued part of that community. Same in this classroom, also in Virginia. Black kids, left by themselves in the front while the white kids, are a row apart from them. So the lesson of the book is, again, not that desegregation was bad, but the desegregation, unfortunately, often ended up in the hands of people who did not have the best interests of black people at heart, and who often carried it out in such a way that they undermined some of the traditional black institutions and sent black kids into an environment where now most of their role models were white people who, may or may not have been the best to serve in that role. And so I argue that they found themselves oftentimes more alienated from education and more of the view that education in schools were in some cases a sort of white supremacist institution. And so I'm not sure what the answer is, but I'm not sure how I would have done anything differently given just the constraints of the time. But I think it's just important to acknowledge the kind of tragedy, the human tragedy that occurred for some of the people who saw their institutions destroyed and who found themselves an unwelcome minority in places that often should have been much more welcoming. So, thanks.
Thank you.
Do you want me to go?
You can say that.
All right, I can stay here. Thank you so much. Thank you. Where's my timekeeper? Is it you? All right, I want to make sure I stay on task this evening. Good evening, everyone. I'm happy to be here for this conference and will speak to you for the next 10 to 15 minutes on the Southern Manifesto and Prince Edward County, Virginia. All right, Prince Edward County, Virginia is a tobacco farming, or in 1950, it was a tobacco farming community with about 15,000 citizens and had about as many blacks as it did whites, 45% and 55% respectively. Like all Southern communities in the mid-20th century, Prince Edward County followed segregation laws that established spaces for blacks and whites, inherently regarding the former as inferior. To resist the integration mandates of Brown v. Board, authorities in Prince Edward County kept the promise of the Southern Manifesto and refused to appropriate funding for public schools, thus forcing them closed from 1959 through 1964. The 5-year-long public school closing in Prince Edward County disrupted families, caused financial hardship, and reinforced an inferiority complex within many black school-age children while bolstering a deceitful sense of superiority in whites. The story of the Prince Edward County, Virginia school crisis typically begins in 1951 with the Moton student strike led by Barbara Johns, who is pictured, and another person was Mr. John Arthur Stokes. I call him Professor Stokes, and his picture isn't here because he's live with us in person. Mr. Stokes, please wait. There. So I'm going to make sure to concede some of my time because when I start to talk about that process, we have folk that are here. Barbara John's siblings are sitting here with us today. Will you please raise your hands as well? I won't call you to the front, but I may tap on your shoulder if questions come up. All right, but I'm going to move on for the sake of time. So with John Arthur Stokes, Carrie Stokes, Barbara Johns, and other student leaders, these intrepid students led the Moton school strike. At Moton High School in 1951, nearly 57% of Prince Edward's 3,450 students were black. Though there were obvious disparities in the educational facilities, and they were evidenced not only by the school buildings, but by transportation, length of school terms, and course offerings. Many students in Prince Edward County, though the contrast between the high schools and the white high schools, 2 white high schools, 1 black high school, they would agree that the elementary school examples were probably the most deplorable. There were more elementary school buildings for black students. However, the white elementary school buildings had indoor plumbing, were brick, and often double the size of the schools for blacks, as illustrated in just one example from Prospect, Virginia, one of Prince Edward's 6 magisterial districts. It's probably not hard to tell which school serviced the white children in Prospect and which serviced the black. If you are having difficulty, Peaks was the school for blacks, and Prospect Elementary was the consolidated elementary school for whites. In terms of high schools, Robert R. Moton High was constructed in 1939 for a capacity of 180 students. This was the only school in all of Prince Edward High School that was available to blacks. In fact, it was one of only 12 black high schools in rural Virginia at the time. In 1951, as I've noted already, white Prince Edward County students had two high schools, Farmville High School, that was built in 1922, and Worsham, that was built in 1927. Moton had no gymnasium or industrial shop, no fixed seats in the auditorium, and was half the size of Farmville High. In addition to the obvious physical disparities, Moton administrators were not provided the basic operational supplies unless or until blacks petitioned the school board. By 1947, there were 377 students in Moton, and 3 wood buildings covered with tar paper were constructed to accommodate the overflow. Between the 40s all the way up through the 1950s, a group called the Prince Edward County School League, also referred to sometimes as the PTA, an organization that was headed up by notables like L. Francis Griffin in the community, who was pastor of First Baptist Church, John Lancaster, who was the Negro Farm agent, and countless dedicated parents made up this league. And for at least a decade, they would go to the school board petitioning for better facilities. March 13th, 1951, a bus accident claimed the lives of 5 black Prince Edward County students: Hetty Dungy, Christine Hendricks, Dodson Hendricks, Naomi Hendricks, and Winfield Page. 10 other students were hospitalized. Hetty Johns was Barbara's best friend and cousin. Some members of the black Prince Edward community used the example of the train wreck as evidence that segregation was hardly as benign as some assume. In fact, in the case of the train wreck at Elam's Crossing, Prospect, Virginia, segregation was deadly. The student strike, the strike that organizers began planning in the fall of 1950, happened the month after this train wreck. I'm going to stop a little bit about that student strike because I'm going to ask you to ask the people that actually led the strike, and I'm going to move on. But so be ready to talk about that, and I'm going to move forward a bit. As a segue in, what I'll say is that Carrie Stokes, Professor Stokes' twin sister, wrote a letter to NAACP lawyers Oliver Hill and Spotswood Robinson, telling them about the inadequate facilities. And these lawyers promised that they would stop back through Prince Edward on their way back from Pulaski County, where they were investigating yet another school desegregation suit. So the Moton strike leaders had swung a major blow to segregation in the nation. Their heroism in their home state was met with virulent racism when segregationists pledged to resist the mandates of Brown, as they understood the ruling as a clear abuse of judicial power. Meanwhile, after the strike, these lawyers that promised to come back petitioned a case called the Davis case, and that too had hundreds of signatories and many implications for all of those signatories, and that then became one of the consolidated Brown cases. By fall 1954, white Virginians organized the Defenders of State Sovereignty and Individual Liberties, and Virginia was on her way to massive resistance. Brown II, 1955, ruled that desegregation would happen with all deliberate speed, and ultimately this meant that if desegregation was to happen, black plaintiffs would have to sue for enforcement of the Brown decision. In further preparation to massively resist school desegregation, Governor Stanley appointed the Gray Commission to provide whites the local option to remain in segregated schools. Members of the Byrd organization, however, that I'm sure you've heard about, understood desegregation anywhere as a threat to segregation everywhere and proceeded accordingly. By November 55, the Gray Plan repealed the compulsory attendance law, established pupil placement criteria, and provided state tuition grants for students attending segregated academies. During this time, and I'm fast forwarding, blacks didn't sit idly by waiting for the Supreme Court to decide in their favor. A case that often isn't discussed, I'll probably just briefly mention, but I'd like to talk about it a bit here, out of Prince Edward, was the Hal Allen v. County School Board of Prince Edward case that was argued in '57 by Hill and Robinson, and a man by the name of Thurgood Marshall was on brief from New York County during this case. And the lawyers claimed that their plaintiffs' constitutional rights were being violated as Prince Edward County school desegregation plan did not comply with Brown II's order of deliberate speed. While lawyers were not asking that school districts require desegregation, they considered Virginia's segregation requirement discriminatory. The case was reversed and remanded with directions for the defendants to make a prompt and reasonable start to comply with the Supreme Court order. However, the deliberate speed mandate was difficult to navigate. The district judge decided to allow Prince Edward County 7 years until 1965 to integrate the schools in the county. The judge reasoned that race relations had deteriorated since 1954, and this time was necessary to make certain that children were not traumatized psychologically by desegregation. NAACP lawyers appealed this decision in the U.S. 4th District Circuit Court in May '59, and they argued that a 7-year desegregation plan was not deliberate speed at all. Further, law and order could not be preserved by denying Black children their constitutional rights. I have 1 minute. So after the Hal Allen case, what we know happened is that Prince Edward was the last of Virginia to hold on, to stand their ground with regard to the rhetoric of the Southern Manifesto. After schools in Warren County and Norfolk and Charlottesville had closed for a brief time and then were required to open, Prince Edward, as I said, was there standing their ground. And in '59, holding fast to the promise of that Southern Manifesto, instead of desegregating public schools to comply with the Supreme Court mandate, they closed all public schools in the county. The 19 senators, 17 members of the House who signed the Southern Manifesto, along with the countless number of citizens who supported the segregationist rhetoric, ushered in Virginia's massive resistance and were able to prevail in Prince Edward County for far too long. We should not soon forget the deliberate measures taken in Virginia to block integration. Massive resistance shows us just how misguided leadership can cost disastrous results. This is important information, especially in an election year.
Okay, well, before my timekeepers start my 10-minute countdown, I want to take one moment of kind of personal privilege to say that I'm honored to be on this dais, but I'm particularly honored to be in the presence of the plaintiffs in the Brown decision who are with us. I will tell you that I am teaching a civil rights class this semester at Jackson State. My students had their midterm today. Your names live on. They better live on in their minds today as they take that exam, and not just to my students, but also in my own children who are on spring break but are watching today. So it is a great honor to be with you. I've been tasked with talking about the Southern Manifesto, a state education policy in Mississippi in 10 minutes. That's a big task. It reminds me, for my 15th college reunion, I got a call and said that I was invited back and that the class wanted me to give a talk. And I was, wow, that's really nice. And they're like, the reunion chair said, yes, we'd like for you to talk about the history of the South. And you're going to have 11 minutes. And I did it. So Jamestown to Barack Obama in 11 minutes. I think I can do this in 10. So I'm get going. Justin Driver said something earlier in the first panel that really stuck out to me about how the Southern Manifesto continues to resonate. And really, this is the story I want to tell about Mississippi. And for the scholars in the room and up here, we know about the story of the long civil rights movement, and we must think of the Southern Manifesto as a long story of white massive resistance, but it also didn't invent massive resistance. White folks had been massively resisting black advancement long before the Southern Manifesto, for sure. And in fact, I would argue that in Mississippi, the story of the Southern Manifesto, at the very least, should begin with the creation of Jim Crow and its de jure structure and its invention, really, in my home state of Mississippi with the Mississippi Constitution of 1890. Now, interestingly, after emancipation in the immediate years, despite white protests and violence, the Constitutional Convention that brought Mississippi back into the Union proposed Article 8, which dealt with public education and created a state system of education, leaving it to the state legislature to define the details. When that legislature first met in 1870, it made law a system of free public schools in which all children between the ages of 5 and 21 shall have equal advantages. Those schools were segregated, but they were still there. And in places like the Mississippi Delta, African Americans exercised incredible control over those schools where they were the majority of the population, even as they faced increasing violence, particularly at the hands of organizations like the Ku Klux Klan, which appears for the first time in Mississippi around 1870, the years these schools come into effect. But in the post-Civil War South, it's really blacks in politics, not education, that creates the most controversy. In Mississippi alone, we had a black United States Congressman, John R. Lynch, and we had 2 black United States Senators, Hiram Revels and Blanche K. Bruce.
Prince Edward.
We've only had 9 black United States Senators in all of American history. 2 were from Mississippi. Before President Obama was elected United States Senator, we had 4. So before Obama, we had 4 black United States Senators, 2 were from Mississippi during Reconstruction. A remarkable thing. And of course, as Reconstruction comes to an end, especially that military phase, white Southerners looked to what they called to redeem their power in this era of redemption, and they did so successfully. And really began in Mississippi with that Constitution of 1890 of establishing again the de jure framework of Jim Crow, the social, what I would argue is the social, economic, and political control, white domination of the South. For Mississippi and for the entire nation, I'd argue in particular that the 15th Amendment was the most crucial target because it was vulnerable. The 15th Amendment, which ostensibly gave African Americans the right to vote, actually didn't give anybody the right to vote. Instead, it said that the right to vote shall not be denied or abridged based on race, color, or previous condition of servitude. What whites in Mississippi figured out in 1890 was, well, if it can't be denied or abridged based on race, color, or previous condition of servitude, it can be denied or abridged in other ways. And so, in 1890, they crafted a constitution, followed 5 years later next by South Carolina, a constitution created for one purpose, to disfranchise blacks. They created literacy tests that had to be proven in the state of Mississippi to the satisfaction of voting registrars. You had to actually interpret a section of the Constitution to the satisfaction of a white voting registrar. There were black people with PhDs who couldn't do that to the satisfaction of white voting registrars in Mississippi. Poll taxes, paying for the privilege to vote, property and residency requirements, and the like. Challenged in what I argue is maybe the most important Supreme Court case of the late 19th century, but maybe the least well known, Williams v. Mississippi in 1898, cleared the way by ruling that all of these laws were constitutional because on the surface they said nothing about race, color, or previous condition of servitude, and that cleared the way for what would be called in the rest of the South the Mississippi Plan. And by 1910, every Southern state rewrote its state constitution to reflect the Mississippi Plan. Georgia was the last to do so. Every Southern state that had been a part of the Confederacy rewrote their state constitutions. Done and finished by 1910. I could go over the numbers, but they're swift and predictable. In a state like Mississippi that had 2 black United States senators, by 1964, just 6.7% of African Americans were registered to vote for the next 70 years, of course. Of course, the extra-legal use of lynching throughout the South reinforced Jim Crow. We know that story, too. Mississippi was second in the nation, both per capita and the total number of known lynchings, and known lynchings is an important caveat. We know that there are hundreds, if not thousands, of others who just disappeared that we don't know about. Interestingly, the Mississippi Constitution of 1890 that creates this de jure framework for Jim Crow also created Section 201 of the Constitution that stated it shall be the duty of the legislature to encourage by all suitable means the promotion of intellectual, scientific, moral, and agricultural improvement by establishing a uniform system of free public schools by taxation or otherwise for all children between the ages of 5 and 21, and schools shall be created and maintained in each school district in the county for at least 4 months per year. Of course, that meant free quality public education for whites only, since blacks had been left powerless and disfranchised by that Constitution of 1890 and faced the fraud of separate but equal thanks to Plessy versus Ferguson. Now, since that Constitution of 1890 was adopted, that Constitution that we still live under in the state of Mississippi, Section 201 that created those free public schools has undergone revision, and often at the times of the greatest racial strife. That's probably not a surprise. There was a minor change to it in 1932, but it's really in 1960 that you see the first big change with the likes of Big Jim Eastland, Senator James Eastland, Big Jim as they called him in Mississippi, and the Southern Manifesto in hand as a defense, facing federal orders to desegregate and political leaders who were speaking openly about closing public schools as they did in places like Prince Edward County, Virginia, and throughout the South. The state in 1960 removed the language promoting intellectual, scientific, moral, and agricultural improvement from the Constitution, and it changed Section 201 to say that the legislature may, in its discretion, provide free public schools, but it did not have to. And the 1960 changes were approved statewide by Mississippi voters, all white predominantly, by a vote of 176,000 to about 45,000, unanimous almost. Unanimous in the sense that no court on behalf of black parents could enforce any constitutional right to public education in the state of Mississippi. For black Mississippians over the age of 25 by 1964 on Freedom Summer in my state, African Americans completed an average of only 6 years of school, 5 years less than whites. The state spent $81.64 on every white student, $21.77 on every black student. 1965, freedom of choice comes along to promote desegregation, but this is a segregationist strategy. We know what freedom of choice really meant. The idea that you would be free to choose where to send your child in a school district completely ignored the reality that very few black parents were going to be the first to choose send their children to an all-white school. And the fact that a few did and faced the violence and intimidation that they had to face gave more fodder to segregationists, because they could then say, look, this high school has 2 black kids in it. They could say, we're desegregated, right? Finally, in 1969, Alexander v. Holmes, that's Holmes County, Mississippi, ended freedom of choice, and desegregation finally came to the state of Mississippi. In the middle of the school year, January 1970, in the middle of the school year, 80,000 white students left the public schools. January 1970. 10,000 left the public schools in Jackson Public Schools. That was 40% of the student body population in Jackson Public Schools, January 1970. An enduring legacy, right? At the same time, the state of Mississippi provided funds to construct segregated citizens council schools in Mississippi and gave tuition assistance, vouchers, to white children who couldn't afford to attend those schools. Then in 1987, voters in the state approved the recommendation by the legislature to completely eliminate Section 205, which forced every county to have public schools. Now, fast forward a little bit as I'm running out of time. Unexpectedly, but still part of this continuum, in 1997, the Mississippi State Legislature passed another law. This is important. The Mississippi Adequate Education Program, that's what they called it, the Mississippi Adequate Education Program in 1997, MAEP, which created a mandated funding formula that the state legislature imposed on itself to fund what it called or deemed adequate education in the state of Mississippi. Since 1997, 20 years, MAEP has been fully funded twice since 1997, state legislature breaking its own law. And for each of the past 5 years in the state of Mississippi, MAEP has been underfunded by the tune of $200 million a year. That's $1 billion in the last 5 years of underfunding what the state legislature defines in its own terms as adequate education in the state of Mississippi. What are you left with if you underfund what you define as adequate education in the state of Mississippi? Interesting, and this is kind of the coda here, just last year, the citizens of the state of Mississippi created a constitutional amendment that would go out for a vote in 2015, Initiative 42. That constitutional amendment, Initiative 42, was meant to force the state legislature to fully fund its own law by creating oversight in the courts. Opponents of Initiative 42 ran an expensive smear campaign, dollars that mostly came from outside the state of Mississippi. They ran negative ads on television. If you were anywhere in Mississippi, you saw anti-Initiative 42 ads on TV and radio. And in an ominous voice, the narrator would claim that if Initiative 42 passed, public education in the state would be put in the hands of, quote, a Hinds County judge. Now, considering that Jackson is the seat of Hinds County and is majority black, the scary unnamed judge was clearly meant to be African American. Republican State Representative Bubba Carter, yep, his name is Bubba. Representative Carpenter, screwed up his talking points at the 2015 Neshoba County Fair. The Neshoba County Fair, where Ronald Reagan kicked off his presidential campaign in 1980 talking about states' rights, which is not even a thinly veiled racist euphemism. The Neshoba County Fair outside of Philadelphia, where in 1964 Goodman, Schwerner, and Cheney disappeared and were later found murdered and buried underneath a dam. Speaking at the Neshoba County Fair in 2015, Bubba announced that, quote, if Initiative 42 passes in its form, a judge in Hinds County, Mississippi, predominantly black, it's going to be a black judge. They're going to tell us where the state education money is going to go. He wasn't supposed to say the black part, but he slipped. Not to be outdone, our state legislature, for the first time ever, utilized its constitutional right, dating to 1890, to submit an alternative amendment to the Constitution rather than Initiative 42. They're allowed, if a constitutional amendment is on the ballot, the legislature is allowed to submit an alternative amendment to it. So you would have two amendments to vote for on the ballot. This is the first time they had ever done so, just last year. The first time they had ever done so, and Initiative 42 had been put on the ballot with over 200,000 signatures in Mississippi. In a state of 3 million people, that's a lot of folks, all right? So the legislature's alternative Initiative 42A removed the court's oversight and required that voters who wanted to support Initiative 42 actually had to vote for it twice. You first had to vote to approve amending the state constitution, and then you had to vote on whether you supported 42 or 42A, with just minor changes in the language. Not surprisingly, Initiative 42 lost. About 46% of voters ultimately supported it, though. So all of this is to say that in order to understand the Southern Manifesto at 60 and that enduring legacy, we must understand this long history, and there's much more that we could go into, but thanks.
Well, thank you for having me as well. So I'm going to talk about a story, one aspect of Georgia's particular response to Brown. And I'm going to echo some things over the course of this story that some other panelists have talked about. But I think this will be a good segue into the next panel and kind of where we are now. So Georgia's response to Brown, like a lot of other states, was to look for ways to get white kids out of potentially desegregated schools. And one of the ways they did that was passing what's called the Tuition Grants Act, which was a pretty clear and straightforward voucher bill in 1961. You can see it basically says all the children between the ages of 6 and 19 residing in the state shall be eligible to get a grant to be expended at a public or private school of their choice. In 1960, I think it's fair to say Georgia had done very little to implement Brown by that point. Governor Ernest Vandiver's chief of staff, Griffin Bell, considered ways they might look like they were doing something. So he came up with this idea of the Georgia Commission on Schools. And the commission's purpose was to hold a series of statewide hearings in each of Georgia's congressional districts, kind of a listening tour to learn about what the citizens thought the state should do about Brown. They appointed the commission. The governor appointed a well-known attorney and businessman named John Sibley to lead it, and it kind of became known as the Sibley Commission. And in all of his audiences, he would talk about what's going on in the state, what they thought the state might want to do, and then he would present the audience with two options, called Option 1 and Option 2. And Option 1 was to have the state continue full-out massive resistance, knowing that It was against federal decisions and may have future negative outcomes in the state. This was in 1961 or 1960, so right after Prince Edward County had closed down. So that was the first option. Option 2 was called the local option. Under the local option, each system could decide for itself whether to desegregate. So Georgia could be seen as moving towards desegregation, and it would make assaults on that a lot harder to fight. There was no option 3, which might have said something like the state will just comply with Brown versus Board of Education. So the witnesses would speak. Sometimes they would speak for themselves. Sometimes they would say, I'm speaking on behalf of the 500 people in my congregation or the 1,000 people in my county or whoever they said they spoke for. And then Sibley would hear all the witnesses and take a vote among them. So on the one hand, you could vote for option 1, which was to continue full-out massive resistance and maybe shut down your schools. Sibley also talked a lot about the economic consequences that were occurring in other states that were fighting back so hard. Or you could do option 2, which was the local option, where if you wanted to desegregate, you could. So the vote totals basically were almost 2-to-1 in favor of continuing massive resistance and shutting down the public schools, which might be seen as kind of surprising by some, or not. However, so based on all this information, the commission then had to write its report. The commission did not recommend continued massive resistance. Eventually, they wrote a majority report and a minority report, and it was a close vote there too. Well, not two. It was a close vote there. 11-8 signed on to the majority report versus the minority report. So this is maybe kind of a scary word to use these days, but the establishment, I guess, of the state decided not to vote to continue massive resistance. What they did was they voted to go with option 2, and part of what came out of that was the Tuition Grants Act. Even the majority report, though, opened up by saying Brown is unsound on the facts. It's pointless. It's unworkable. But then it went on to say, but it's the law of the land. And then the minority report was just a scathing attack on how the elites of the state were ignoring the will of the people and not continuing to massively resist. So for his part, Governor Vandiver said years later that the reason he decided not to go down the path of continued massive resistance was that he didn't want to be another George Wallace, or he didn't want to be a martyr and go to jail and wreck the economy of Georgia at the time. He felt in 1984 that things could have worked out more gradually if they had just been allowed to kind of operate on their own. Two things I think operated on Vandiver from when he campaigned as a segregationist and when he decided not to continue his resistance, his massive resistance. One was Prince Edward County. He would make arguments that there was no way that would happen in Georgia, which Georgia law didn't contemplate it, which was technically true because it hadn't been tried yet. But this was very much on John Sibley's mind, and it was one of the reasons he didn't want to continue down that path, because it would have shut down the public schools in the state. Sibley thought it was a major precedent. And the other one was that the University of Georgia desegregated, and which included a lot of the children of the current legislators at the time, and they were alumni, most of them. And so it became much less appealing to shut everything down when that was going on. Governor Vandiver's successor was Carl Sanders, who was more of a moderate for the time. He was elected in 1962. He kind of campaigned and acted more as a moderate and tried to sell this idea of the New South. Here's what he said about the act. Basically, the punchline is, I campaigned and I grew up as a segregationist, but I'm not a damn fool. He didn't want to shut down the public schools because he knew it would hurt the economy of the state. The law passed, the act passed in 1961 the session of the Georgia General Assembly. There's some disagreement about whether anyone actually got a grant out of it. The newspaper published a list of names, but interviewed later, none of them said they actually got any money. So maybe they were considered eligible, but they never got paid out. Carl Sanders kind of effectively vetoed it by just choosing not to do anything with it. The act was amended a few times over the years. Almost immediately after it was passed, it was amended to change the wording from saying that every student was entitled to a grant to every student was eligible for a grant. And every school system had to hold a hearing to decide whether anyone really needed a grant. So you can guess how many of those hearings ever happened, right? 0. So effectively, the law kind of languished and didn't go anywhere. It was kind of dead letter for a long time. But here's the weird turn. It was amended, but it was never taken off the books. So in 1993, an Atlanta attorney named Glenn Delk, who's still active in school choice around town now, no, I think Gerard knows him, noticed the law was still on the books, but what he did was interesting. He tried to use that same law to basically get vouchers for minority kids in 3 different school systems around Atlanta. So Atlanta Public Schools, Fulton County, and Cobb County. So of course, these families applied for grants to their school system. Of course, the school system said, no, we're not giving you grants. And so of course, it turned into a lawsuit, right? So here are some of the arguments that the two sides made, right? Glenn Delk's arguments are basically, these kids, the law may have been passed for the wrong reasons, but we want to use it for the right reasons. These kids are in poor schools now. They're not performing well. We just want to give them an opportunity to have a better school. The interim superintendent of Fulton County at the time had an interesting argument, which was that if they were forced to give grants out, thousands of kids would run away from their school system. So his argument was, if the kids are given a choice, they will absolutely take it and run away. So the case went on. The plaintiffs lost on the grounds that the funding mechanism had changed a few times over the years, and there was really no way to fund the grants. So no one ever got a grant in the 60s or the 1990s. Glenn Delk appealed in 1997 to try to force the school systems to at least hold hearings and say, yes, we should give grants, or no, we're perfectly high-quality systems and we don't need to. He lost on that too, and the act was, or the appeal was dismissed on May 17th of 1997, and then the act was officially removed from the laws in 2005. So in my couple of remaining minutes, some takeaways from this are, questions. Was there popular support for the act? In the 1960s, so this is a picture from Virginia, not Georgia, but that's the picture Georgians were trying to avoid having to take in the 1960s. So the act was not very popular in the 60s, but honestly because it was seen as too moderate or even too liberal at the time, right? Most of the citizens wanted to continue massive resistance. In the 1990s, it wasn't very popular either. There wasn't a huge groundswell of support for Glenn Delk's efforts. He had to go out and recruit his plaintiffs, and in fact, he had a letter that he sent around saying something like, your kid is eligible for an act. Please sign this, and we'll see if we can get him one. He didn't get very many takers. We do still have school choice in Georgia, as we have all over the country through residential, right? It's kind of hard to see, but this is a sign advertising homes that go to Riverside Elementary, right? So you can buy a house where you want to have your school choice, right? That hasn't gone away. What were the goals in the 1960s? Very clearly to promote or prolong segregated schools. In the 1990s, it was really intended to offer opportunities to kids, to get them out of poor performing public schools and into better performing private ones. And then in implementation, I think this is a really important point. In the 1960s, the elites of the time wanted to impose their will, and they did so through the act, right? This was a way to continue what Jeff Roshi calls restructured resistance instead of massive resistance, right? So they could keep prolonging segregation, but not massively. And then in the 90s, the same thing happened, but the elites were the courts and the school systems who refused to go along with the act and offer grants. So I think it's really interesting that, just as I wrap up here, this power of public schooling as an institution. So when public schools came up against segregated schools, the state decided to keep the public schools open rather than shut them all down, as they did in Virginia, right? Implementation matters. Governor Sanders slow-walked it, and then it died on the vine. And then I think for today, there's a lot of hurry and push to get as many choice bills passed as state legislatures can. But I think what gets lost by a lot of policymakers is there's a living memory of people in this room, for example, who were the victims of laws for choice that work to keep opportunities away from them. Georgia is an interesting example because literally the same language of the same law was used for two different ways. So this is an interesting story that I think is not well told.
Thank you. So, Dr. Luckett, when we hear Mississippi, we know, of course, Southern Manifesto, states' rights ideology. We think of Eastman on one side of the fence. On the other side of the fence, you may think of Marion Wright Edelman or Bob Moses. Mm-hmm. But you often don't hear John T. Patterson. Who's he?
Well, John Patterson, I think, was the governor of Alabama. Joe Patterson was the attorney general in the state of Mississippi. Mm-hmm. But they weren't related. But Joe Patterson was Mississippi's attorney general from 1956 to 1969, basically covering the entirety of the modern movement. I came across Joe Patterson doing research because he's the named litigant in every civil rights case. It's the NAACP, and they sued the state of Mississippi. It's Joe Patterson in the state of Mississippi. But his son introduced me to him even further when I was in graduate school, and he said, we were talking about my interest in research and civil rights, and he said, I have a bunch of my dad's papers in the attic. Would you like to look at them sometime? And as a graduate student, you're thinking, oh, yeah, sure. And that eventually became the book that I wrote. The story of Joe Patterson is really the story of the evolution of segregationist politics and the kind of breaking down the mythology of white racists in Mississippi as all being dumb, pot-bellied, tobacco-chewing, gun-toting, racial epithet-spewing bigots. There were plenty of those, and they were dangerous, but there also were sophisticated racists whose language and politics worked pretty well and lived a very long time, and in many ways never disappeared. So the story of Joe Patterson in my book is really the story of what happened to segregationists. We almost assume that the civil rights movement, when I say we, I'm talking about not the people in this room, but kind of in the national consciousness, we assume that, the civil rights movement won and all the segregationists packed up and moved to Tahiti or something. But they didn't leave, and they're, in many ways, are still in power. Those 80,000 white kids who left the public schools in the state of Mississippi in January 1970, think about who they represented. They represented a power structure and a moneyed structure that to this day is still in power in the state of Mississippi. And so it's really that story, the long story of the civil rights movement and resistance.
So Eric, you bring up an interesting part about Delk. We both know him as an attorney. 1961, the state made a conscious decision to say we're going to create the education grants and give them away. Were there any black families who received grants? And what was, at this time, you're in Georgia, so the King family is still pretty important, Benjamin E. Mays, still involved with Morehouse College, strong black business community as well. How is this intersecting the politics?
Yeah, so it's likely that no one ever got any money out of it, white or black,
okay.
Right? The act was passed, and then they kind of let it die on the vine. I think one of the advantages Georgia had, honestly, was the city of Atlanta, and the economics behind it. We had a lot of bigger corporations maybe than some of these other states did, and so you hear stories about behind the scenes, like Robert Woodruff from Coca-Cola. Or as Flannery O'Connor might say, Coca-Cola, kind of in the background, sending people to send money and support these kind of things. Sibley, you talk about finding boxes. Emory houses John Sibley's papers on this, and he got a lot of letters after the commission happened, and They read kind of like the comment boxes on a blog somewhere. So there are very supportive ones. You're doing God's work. You're on the side of the angels, and then other ones that say you're basically a communist and you belong with Benny Mays and working on his side. So, yeah.
So, Amy, you mentioned Mr. Stokes, we know, who's in the audience. When people hear Prince Edward County, they're shocked to know the schools were closed from 59 to 64. They kind of know about Prince Edward County because of Brown v. Board, but they know little to nothing about what is known as the strike. What's the strike?
Mr. Stokes, would you respond to that question, given that you're here? Could you talk about the, I'll help, I can help.
He's got a mic now.
Okay. Mr. Stokes, in terms of briefly talking about that student strike, I know that you and a lot of other students at Moton were voracious readers. You read a lot, especially the newspapers. I know that you've talked with me about that personally. You write about that in your book. And sometimes you might even get your hand on crisis magazines. Well, this is way before your time, but 1934, there was an editorial written by W.B. Du Bois. And in that crisis editorial, he wrote regarding segregation, there should never be opposition to segregation pure and simple, unless that segregation does involve discrimination. Blacks should fight against the refusal of the South to spend the same amount of money on the black child as the white child for his education. When you all went on strike at Moton, what was the purpose of that strike? What were the initial goals?
The initial goal at Robert Rooster Moton was equality. We went on strike basically to get a new building. Interestingly enough, because of the fact that lawyers came to us and talked with us and convinced us to do otherwise. But let's go back a little bit. Because of 2 minutes, okay, I see you, Mr. Robinson.
Got to be the heavy.
I may be 84, but I see pretty well. May I stand, please?
Oh, sure.
I feel better if I stand.
Absolutely.
Okay.
Yes, sir.
What happened during that era, ladies and gentlemen, to put it point blank, was we were being disenfranchised. We were being disenfranchised, and we were being programmed for failure. You see, Dr. Tillotson showed the school buildings, but the fact of the matter would be the property value for the white schools was $1.7 million. The property value for the colored school, we weren't called black then, we were called colored, was $875,000. Yet there were more colored children attending schools in Prince Edward County than white students. We were being disenfranchised in regards to the buses and just the equipment itself. And our teachers indicated to us that we must do something. Her sister, Barbara John, became the strike leader. We followed her. You can check it out in Simple Justice by Kluger. He indicates everything, including the writing of the letter and things of that nature. And based upon that fact, we decided that we would go on strike. We did not go on strike for integration, ladies and gentlemen. We went on strike for equality, for a new building, and for other facilities. But when Mrs. Barbara Robinson, Mr. Oliver Hill talked with us in Reverend Griffin's church that evening, they said to us, you have to let us take this case, not for equality, but for non-segregation. We didn't use the word integration there, non-segregation. And that was the beginning. Our case was the only case that was student-led. Of the 5 cases, our case was the only one that was student-led.
Thank you.
Did I answer your question?
Yes, sir. He happened to mention Simple Justice, which is the book we have here, but I also have a copy of Mr. Stokes' book on the strike that you should pick up. We're now going to open it up to the audience for questions. Again, given the time that we have, we want to make sure we get questions in. And we have mics. We have a hand in the back. We'll start over here.
Hey, Bob Moranto, University of Arkansas. I have kind of two things to throw out. One is Catholic schools seem to be desegregated a lot earlier and without trouble, and without violence. And I wonder if anyone wants to address that. A second related question I want to see if anyone wants to address is business had a huge role in this, in that Atlanta wanted to keep growing, unlike Birmingham, which meant you don't want trouble. How does that maybe lead to some good impacts, but maybe also some bad impacts, and that people were looking at public relations and things up here at 50,000 feet, and not what's actually going on in schools and communities? So either of those, if you want to address them.
Okay. Anyone who wants to go?
Well, I will say something just about the Catholic schools. In the state of Mississippi, of our private academies, the only historically white academies that existed before 1954 were our parochial schools. They were the Catholic schools, the Episcopal schools, the Jewish schools, and then historically black schools like the Pineywood School that is over 100 years old now in Mississippi. So the Catholic schools, I mean, since 1954, you cannot find a private academy in the state of Mississippi that's not a parochial school or historically black school founded before 1954. So the Catholic schools were historically segregated, even though they existed before 1954, but began the process of desegregation a little bit earlier, but not without resistance, and with continued resistance to this day, including in Jackson, white flight of the Catholic school to the suburbs, moving from a predominantly black student body population to a predominantly white student body population today, and that's happened in the last 10 years. And so it is a little bit of a complicated story, so it would be difficult for me to kind of make a real complete argument in the few seconds that I'm here. But there is something to be said about, particularly with Catholics and with Jews, the common minority status in the South. But you got to be careful, because Southern Catholics and Southern Jews were also white, and many of them chose their whiteness over their common minority status. But there were some who felt a tie to the movement. Some, not a lot, some.
Anyone else want to answer?
Yeah, so I said a little bit about Atlanta already, but it's very evident that the leadership in Georgia, and really that really means Atlanta, they were very aware of companies not coming to other places because of the way things were going in states like Mississippi and Arkansas and places. So even if it doesn't make its way into public documents, privately they were very aware of losing out on economic opportunities.
Question on this side of the room? None? Or this side of the room? Oh, okay. Yes, ma'am.
Okay. The strike was led by our sister Barbara Rose Johns, and she recruited other students, including John Stokes, to help her carry out that mission. But the idea came from her. She was dissatisfied with the school that we attended, because we didn't have adequate facilities. So she decided one day that something needed to be done about it, because the school board had not answered our parents' inquiries about why we didn't have a school that was adequate. So this was something that our sister thought of and got other students to help implement it. So I just want to say that, because that is what happened with the strike. Okay?
And I was privileged when I was Secretary of Education in Virginia to attend the General Assembly event where they had the unveiling of the portrait of Barbara Johns. She was 16 years old at the time, and so for young people who think you can't do anything at 16, know that you actually can. Any question on this side of the room? Yes, ma'am. We have a microphone for you.
Sorry, thank you. And I was with the Briggs versus Elliott in Somerton, South Carolina. And when she spoke about some of the things, how people felt and all, it was not like that in Somerton, South Carolina, where that case came from. And the reason I wanted to say something was because of the fact that, I'll tell my age, I'm 74, so when you realized that I was born in 1940, then I was a young girl, but I thought I was a grown-up. And I spent my life from the time I was 5 trying to be around grown-ups and listening to what they were saying. Now, they put me out of the room many times, but it was something exciting to me to see older people sitting with a newspaper and staying all day in that rocking chair reading that newspaper. I couldn't wait. My mom said I was 3 and a half, but I wanted to read because I couldn't figure out what could keep you there that long. And so I got to accomplish those things. But what happened is that the teachers in Somerton at this high school there, or at the school, there was one school, and the one point I wanted to make, my mom was young, but her sister was older. And what they told me about when I got interested in it, and that was after I was married and my ex was in the military, and we were traveling all over, and I'm still traveling all over different places. But what I realize, and I hope that everybody, and I'm sure so many of you are so well-versed and you know so much about this, so much more than many of us who were in it. But what happened is that the people there, at least in that community, or at least in that area, they were just passionate about learning how to read and learning how to be intelligent about things and discuss things. And that comment about it takes a village, when at least in the area where I was, everybody grew. It wasn't just your mom and your dad, and you say, who were your role models? Well, they were your parents for the most part, or aunt so-and-so, or whatever have you. And there was, so young children like we were, you had so many people there who were loving you, teaching you, training you, all these kinds of things, and giving you all the love and attention you could possibly want.
Okay.
So that's why a lot of us, unlike me, like I said, who had to be sent out of the room because I wanted to hear everything, that's the way many of them grew up. And what happened is that the teachers in the school, and there was one Somerton school where all of the children are all ages. Now, when you see a lot of movies and things, they show the worst because I guess that's what most of them look like outside of the city. What happened with Somerton, and you'll hear things and all, my mom used to get angry about that because
we're
she
gonna have to
felt, I'm sorry.
Just really quickly, we're going to have to.
Okay, what happened is that she felt that they tried to make it look like everybody was so poor, so dumb, so whatever, and that just wasn't the case. She always resented that. Up until the time she died, she resented that because she felt they weren't. That route to Somerton was how anybody who was in the northern states, if they wanted to go to Florida, that's how they had to go through that little town. Mm-hmm. And what happened, Thurgood Marshall and so many others had learned from a case that got thrown out because the people weren't living actually in the district.
Correct.
So he made it his work to make sure that if he brought another case, that case would not be, that case would continue all the way up. And so that was an incredible kind of thing. So what would happen is that high school students were supposed to get a mimeograph, something for their diploma. And that just tore the nerves out of everybody. But everybody was with that. Everybody wanted those schools to be better, and they wanted all of those things. And so when you read about many of these things in many places, you really have to go a lot further than that one or two people you might talk to, because it was different depending upon the family, the community, the whatever. My dad was collateral damage, I would say, and that affects your children for a long, long time.
Thank you for sharing that personal story. One of the things with any event is there's a time where we've got to move these people to the next panel. But before we do, the number of them are going to stay. I believe Dr. Tillison Brown has to actually leave, but her information we can make available to you. I want to thank each one of them for their state story. It's a part. There's more research to be done. And with that, let's give them a round of applause.
Good job. Yeah. You know, I was teaching about Mississippi and saying that was actually more.
If you're on the next panel, make your way to the front. We're going to begin promptly at 4:45.
Of course. Yeah, exactly. You're right.
Promptly at 4:40, excuse me.
Yes, yeah, exactly. Right. You might can pass a Dyer bill or two. That's right. Yeah. Oh, no problem.
I just had to
I'm
hear his
actually
name.
going to stay. No, I'm staying. I'm staying. Yeah, yeah.
Okay.
I'm going to stay.
Okay, thanks. Scott Jensen, thank you. Can we have Assistant Secretary Clay House, Kenneth Mason, Attorney Riviera? Oh, yep. All right. She's going to tell you where to sit.
I follow directions.
Yes. Okay.
I'm Scott Jensen. Pleasure to meet you. Did they tell you where they want you?
Okay, can we have Ken Mason to the front as well as our other two speakers?
Hi, I'm Sarah. I'm going to be doing the time card. Yes, we could get 4 waters. 5, actually. Thank you. Oh, you got the water, so I should put this on. Yeah, they'll bring you. Thank you for your talk. How did you want it?
First is the House, and then Ken, and then Wendy, and Scott is last. All right. Okay, we're going to begin our session. So as you notice from the second panel, we had a very robust discussion about the role of state education policy in the South, particularly after the signing of the Southern Manifesto. It led to massive resistance in a number of the southern states. And some of the collateral damage to come out of that are conversations today. There's one term that Eric mentioned, freedom of choice, and we find that term in play today. And so we have 4 people who are going to have a conversation today about education in the South today, particularly in the southern states. What lessons have we learned from the past, and what can we do now? Our first speaker is going to be Tanya Clay House, who is the Deputy Assistant Secretary of Education. She made a note, she'll be right back before we get started, in the Office of Planning, Evaluation, and Policy Development at the U.S. Department of Education. She is an attorney and has spent a great deal of her time in cases dealing with equity and school reform. Next, we'll have Kenneth Mason. He is a member of the Georgia State Board of Education. He's also a former teacher with and involved with TFA. He earned his undergraduate degree in physics and then became very interested in school reform. And Ken and I had a chance to actually become co-founders of the Kips Drive Academy charter school in Atlanta, which this year is the Charter of the Year in the School of Georgia. But he's also working with the Southern Regional Education Board, vitally important to conversations about the South. He's also doing work educating kids about civil rights. Next, we have Wendy Rivera, who I had a chance to meet during my time in Florida. She is also involved in school reform in the southern states, Texas, all the way to Florida. She's a board member of HCRAIL, which is an organization of Hispanic leaders who are dedicated to school reform and opportunity and options for families in the South. We know today that of the 50 million students we have in the United States, you're having a major shift to a majority black, brown student population, and the Hispanic community is growing particularly fast. And so any conversation about education in the South will also include the Hispanics. Last, we have Scott Jensen, who works with AFC. In a previous life, Scott was chief of staff to then Governor Tommy Thompson in Wisconsin when they became the first state to pass an urban-based voucher program for Milwaukee. He then later became the Speaker of the House in Wisconsin. He's one of the smartest, brightest, forward-thinking leaders in the country as it relates to school choice, particularly the role that regulation and laws play. And he's been spending a lot of time working in the southern states. He will tell you about the southern states and what we're doing there, and particularly as it relates for schools of choice. So our first speaker, again, Deputy Assistant Secretary Tanya Clay House is here. You have a PowerPoint? Yep, she has a PowerPoint, and we will open with you, and then we will go to the rest of the panelists. Thank you again for being here.
All right. So good afternoon. Thank you again for inviting me, Gerard, and I was happy to be able to listen in on the last panel. I'm sorry I didn't get to hear initial remarks and everybody else, but it's been very educational, and I appreciate the opportunity to talk with you today. So I'm here on behalf of the Department of Education, and I don't know that I'm going to have as much, exhilarating conversation as everybody else has had so far talking about the history, but I want to kind of give you an overview of some of the things that we should be talking about moving forward. I mean, we've heard about the history. We know where we've come from in terms of the segregationist history that we've had here within the United States, and how we're still evolving. I mean, how that we have not gotten to a point where all schools are equal, in fact. And so, but the Department of Education is here and one of our opportunities for all public school students. And so what I want to focus on, I've got a few slides that I'm going to go through, and I'm going to just highlight a few things. I recognize that we always have a time crunch, and I also recognize that I tend to talk long, so I'm going to try to manage my time a little bit here. We've talked about the history, but I now want to talk about the history and the evolution of the Elementary Secondary Education Act. As we've spoken about Brown v. Board and what it has meant to providing equitable education opportunities within our schools. And so moving forward, we then had, as part of the passage of massive civil rights bills, talked about, there in 1964, you had the passage of the Voting Rights Act to ensuring that there was an ability for all persons, particularly persons of color, minorities, voters, to be able to vote unencumbered without barriers. And so we're still fighting that fight. But in moving forward, we also had other revolutionary bills that were passed, particularly the Elementary Secondary Education Act. And inherently, that is a civil rights bill. And I want to put that in that context so people understand what it is that we're trying to do right now. And if you talk about the ESEA, it has many different names as we move forward, but the origination of this bill, Elementary Secondary Education Act, ESEA, is a civil rights bill. And it's something in that we at the Department of Education hold firm to. And so let me talk about how it is that, as I said, our mission moving forward is to promulgate the original intent of ESEA. And then the Department of Education, in its creation, its formation, was to provide services, provide grants to states and to localities to ensure that type of distribution of funds, to ensure that we actually had this type of educational opportunities that are provided to all students. So as I said, we've come a long way. We've had a lot of progress, but we still have a long ways to go. And I think it's important to talk it's important to acknowledge that we have had an increase in our school graduation rates. It's at an all-time high, 82%. And we're very encouraged by that. We also know that there's still a gap that exists between white students, African American students, Latino students, that this is students with disabilities, Native students, that gap still exists. And we're at the Department of Education trying to close that gap in many ways, not only on graduation rates, but on so many other disparities that exist in our schools. And so as I said, we're also excited that since 2008, we've had more Black and Hispanic students, having enrolled in college. But again, we recognize that race, your economic status in life is still a predominant indicator of where it is that you are on the school achievement level. And so at the department, and as I said, we know that again, students that are more affluent are six times more likely to complete college than students with the lowest family income. So we are faced with that reality, even though we're encouraged by some of the opportunities that we have seen for particularly our graduation rates in all students. So I'm going to focus on a couple of things that I think will highlight some of the equity provisions that we're trying to pursue, particularly talking about the Every Student Succeeds Act, which was just passed by Congress and signed by the President on December 15th, 2015, as well as our budget, and talk about some of the proposals within that. I just like to show that picture because it's nice. So there are a lot of good things within ESSA. And I think that, and just as a side note, I don't know whether people want to call it ESSA or ESSA. I'm old school. I call it ESSA. I just spell it out. It's just what I'm used to. But in any case, ESSA has a lot of critical protections, particularly for our disadvantaged and high needs students. Let me just highlight a few things. Particularly, it ensures that our low-income minority students are not taught at disproportionate rates by ineffective teachers. This is specifically highlighted within ESSA, and I bring this to your attention because it's something new that I think we need to pay attention to. It's something that there are reporting requirements, but not before, even in NCLB, did states have to actually account for the disproportionality that exists for students of color and for low-income students who are being taught by ineffective teachers. And so it's ineffective, inexperienced, and out-of-field teachers. Secondly, I want to highlight the fact that there's an increased role of poverty within Title II and within our Title II funds, which goes to teaching and professional development and our education and opportunities for all of our educators. And there's an increase of poverty in allocating those funds so that we can actually get the dollars to where they're most needed. And that's something that we highlight. Additionally, there's more protections, particularly for homeless students, for foster care students. Oftentimes, we know that those often have a disproportionate impact upon students within communities of color. And it also increases transparency for equity data, which, again, is very important. If we don't know where the disparities exist, then we're not able to actually close those gaps. This slide just gives you a little bit more information about some of the increases in funding that I'd like to show that we have. Within the president's budget, even as we're trying to implement ESSA, we need money in order to implement these programs. And so within the budget, we've called for increased money within Title I, which goes to those schools that have a high rate, a certain amount rate of low income students within their schools. And so we've called for increases in funding. We've also, I'm going to go to a couple other slides, encourage the expansion of early learning, because we know in my title it says P through 12. That means that we know that learning starts in the preschool level. We've called for increases in learning, increases in computer science opportunities for all students, because that is what we know is going to provide that economic stability for the long term for all of our students. And I also want to highlight that we've also called for the increase in our budget for the Office of Civil Rights, because while we are trying to make sure that we have opportunities within our schools, we have to enforce the laws that they stand right now. And so make sure our students are not being bullied and harassed. Make sure that they are not, again, being disproportionately impacted by unfair disciplinary rules and that are being enforced unnecessarily by student resource officers who are not all the time trained to be in those schools. Things like that. So that is something we've also called for increases in. Now, I want to focus on a particular component within the president's budget, something that I think is very important, and I think speaks to some of the issues that we're talking about also today with the Southern Manifesto. And this is an initiative called Stronger Together. And the focus on Stronger Together is to highlight some of the other things that we've always done. We believe that in order to ensure equity in our classrooms, well, I could say equity in our schools, but also in our classrooms, because you can have segregation within the schools. You can have all the students all minority students in one set of classrooms and all white students in another. And so we're encouraging comprehensive look at how it is that we can change that structure to ensure that we actually have diversity in our schools and in our classrooms. A comprehensive structure that not only includes trying to move people around. So we support things like magnets, and we continue to do that within our budget. We call for increases in magnet school programs, which encourage the desegregation of our school. Well, that is the foundation for magnet schools is to desegregate our pockets of that have racial isolation, but also we call for increases in charters. That, though, is something that we would say is incorporated into this Stronger Together proposal, in which we're incentivizing local school districts, a consortium of school districts, to come together and create a unique model in which would actually create the diversity that is necessary to achieve equity. And I want to be clear that we're not saying diversity for diversity's sake. We believe that it is necessary in order to obtain equity in our educational environment, that we have to have diverse environments. And so that's what Stronger Together is about. It's $120 million. It's a small pittance of what it is that we ultimately need to be doing. But it's something that we believe is very important and something that we think we're encouraged by and that we hope people will support not only now, but moving forward, even beyond this administration. We know this because the focus is on we talk about equity, and we know that at least 24% of our students are attending schools that are 75% minority or low income. And they're not receiving the services. And when we talk about Brown v. Board, it was about equality of opportunity and services that are provided in our schools. And again, we want to focus on that socioeconomic the status, that the socioeconomic diversity that is necessary in our schools to make sure that we have that equality of opportunity within our school system. So I leave with this quote that we all, I'm sure, are very familiar with, but I also like to leave with another quote because it's something that, particularly this an election year, is, I think, very meaningful. Thurgood Marshall is a hero of mine as an attorney and someone who has got parents who are in the educational system. I always looked up to him, and I always believe that it's important to emphasize, to talk about, he talks about you can't just, when you talk about pulling, that where are we now today? We didn't get here by ourselves. Everybody, you didn't just pull yourself up by your bootstraps. But I'm not going to go to that particular quote because we all know that bootstrap quote. But I like to talk about how equal means getting the same thing at the same time and at the same place. That's what equality is. And in this, where we are right now, and this, as we're in the midst of an election, I want to also emphasize how it's important to exercise your vote in a way that ensures that we are looking out for all students and that equality of educational opportunity. And I hope that, and what I often like to leave with saying is that the vote is the most important, powerful instrument ever devised by man for breaking down injustice and destroying the terrible walls which imprison men because they are different from other men. Whoever it is that we are trying to work with and move forward in this election, I think we need to keep that in mind because it's up to us to determine who we're going to have in office to make sure that we are ensuring that equality of opportunity for all our students moving forward. Thank you. That was President Barack Obama.
Oh, thanks. All right. Hello, my name is Kenneth Mason, and Gerard reminded me of kind of my start in education reform was growing up in Arkansas, being interested in things like physics. I'll call it the soft bigotry that I faced early on in middle school and high school, and then got hit in the face with it hard in college. Got a thorn in my paw. And from then on, decided that I needed to throw myself at education reform, throw myself at the challenges that my little brothers and sisters would face in the future, so they wouldn't have it so hard. But the reality that I was facing was nothing compared to the reality you all faced. And learning that history has broadened who I am in education reform. I work for Southern Regional Education Board, founded in 1948. Now let's think about what was going on in the South in 1948, the context we've set all day. This organization still exists as a nonprofit, nonpartisan. I think the nonpartisan part is why we remain successful. Nonprofit, nonpartisan, interstate compact for education. Built to increase the collaboration between education leaders and leaders in the government so that not only education could change, but economics could change in the South. This was all stimulated by Roosevelt, President Roosevelt, 1938. His council, his National Emergency Council. The quote, I have one quote up there, but I found a better one. The existence of an acute and national economic emergency which affects the national public interest and welfare. Speaking about education in the South, speaking about the South in general. So 1948, this group, Interstate Compact, mostly governors and legislators formed this organization. Now, working with still 16 member states, now work all over the country in education reform, working with legislators and policy review, research. I work with the largest division now, which is school improvement. School improvement. And so being a part of this organization and having a heart and passion, knowing my history has created a lot of contradictions for me, a lot of frustrations for me, a lot of complications, and I think it's important that you realize what I'm going to present is like three parts of myself here. I'm going to present. This is the fourth part is me as a daddy. Okay. The fourth part, I'm going to just mention this. I have a 1.5-year-old and a 3-year-old, and I am so frightened about school. So frightened about, and so I find myself leaning towards homeschool, and I shouldn't have to do that. Not in this country. Not after the history we've had. So I sit on, for 5th Congressional District, I'm on the State Board of Education. This is Georgia, and this is a map showing our flexibility. We are a state that has embraced education innovation through charter schools, and now we're calling it flexibility. Now we're getting so sophisticated, we call it flexibility. And the blue areas you can see there have very few students in charter schools, but 5.9% of the students in the entire state are in some flexible option in Georgia, and growing, which is above the national trend. So by June 30th of 2015, all the schools in Georgia were to commit to be one of three categories. You're going to be a charter system, you're going to be a strategic waiver school system, or a non-waiver system formerly known as status quo. And you can see how, I mean, this is, letters of intent are in, so this is what the future is looking for us like with flexibility in Georgia, which is very interesting. Number of charter schools since I've been on the board has jumped off. Gerard mentioned that he and I were involved in forming a charter school in Kipps Drive. At the time where we started, which was, Gerard, 2006 was probably when we started, there was no energy in metro Atlanta around charter schools. In fact, we faced a blanket denial. And now, this is the reality in Georgia. Majority of the startup charters serve African American students. Majority of those charters outperform the non-charter schools in assessments. You can look at the distribution there. Also want to mention that the 9 districts that make up Metro Atlanta, are essentially 50% of the student population in Georgia. So we have a dense center for flexibility in charter in Metro Atlanta. A lot of students, but a lot of flexibility there, and a lot of varying success. So I'll switch. Now I'm going to switch. So I've had an opportunity, and so this person fuels me. This person keeps me straight with all of this. This is Minnie Jean Brown Trickey. She is one of my mentors and friends for the last 15 years. I've had an opportunity to design. We started with anti-institutionalized racism workshops for 11th and 12th graders. And we moved on to developing nonviolent workshops for these students. And now we focus on what she calls the American dilemma. And look at our hashtag there. Profound intentional ignorance. She sparks these young people to realize that there is something there, our school system around us, our history and present, there is a profound intentional ignorance of just doing, of kind of moving things forward, saying they're one thing, and we all know it looks like another thing. So the students this year we have given them all the Southern Manifesto document and gotten a lot of interesting opinions on their take on the legislature, comparing the legislators then and the legislators now. You should read some of their comments. No offense. Again, one thing that Minnie Jean helps us recognize when we start talking about schooling, we try to get to a point for these young people and their teachers to recognize that racism exists, but it also, when you talk about racism, denial happens. And it happens by normally blaming, in this case, the student. These principles of nonviolence are normally where we start, and for me, this has been a common core for me. Number 2, win friendship and understanding. When I sit on the state board, the only black male, the youngest person there, and try to advocate for quality options for young people and to acknowledge that there are some injustices in the past and currently that we have to acknowledge that that we are one board trying to move forward. And sometimes it's hard to be friends and seek understanding, but this current state board, I'm very proud of the progress we've made, as you see with charters. This is something really personal. This is my mother's school. This is Dean Hill in Lake Cormorant, Mississippi. Wood stove, outside bathroom. This school created one of the most intelligent women that this earth. But it was closed. It was closed. And my father and my mother and I have a debate on this school and the quality. I believe Dr. Buck, you took the words out of my father's mouth. They willed the education into us. Where are our educators today in the future that are going to will education into these young people because it's necessary? They have to have that level of love, develop that level of trust, build that relationship. I did not mention content. I did not mention testing. I did not mention class size. I mentioned love. And so that school brought a lot of love to those children in that community. And Gerard Robinson probably was one of the first people that walked into that building. That is Kip Strive. That is the building that we started with when we were denied, and we kept going. We denied by Atlanta Public School, but came back, got our charter. Now it is a National Blue Ribbon school, as Gerard said, #1 school in Atlanta. But what is happening is really interesting now. Grants have created now Kip Primary. One of our founding members have created the K. So Kip Strive is 5 through 8, 5th grade through 8th. Now we have pre-K and kindergarten, 1st and 2nd, 3rd and 4th grade in that building. Multi-million-dollar beautiful building. Now Georgia Beltline is advertising this. And now you see the community around changing it. And now the school may not be for the students that we designed it for. Interesting change has happened. Thank you.
Thank you. And good afternoon, everyone. My name is Wendy Rivera, and I'm thrilled to be here with the high-powered and highly respected leaders. I'd like to thank Gerard Robinson for the invitation, and your colleagues and your team for putting this dialogue together. Very much appreciated. I'm pleased to be part of a dialogue that supports efforts to help more children seek the education that they deserve. And I'll give you a brief background about myself. I know Gerard went through some of the summaries, but I'm a proud parent of 2 kids, elementary school, middle school, and I consider myself a parent advocate, and I'm also a disability advocate. And my husband and I joke around that in my spare time, I practice law in Orlando, Florida. I am a practicing attorney in Orlando, and I handle disability claims. But I'm also the president of a grassroots organization, Multicultural Education Alliance, and it's an organization that works with parents and community leaders to increase student achievement. And I serve on the board of HCREO, and HCREO is the Hispanic Council for Reform and Educational Options in Florida. And just for everyone here in the room, HCREO is the only national public policy Hispanic organization that focuses on K through 12 education reform. We advocate for parents, for children, and it was founded to address the crisis that exists in education in the Latino community. And we provide parents with free information and resources so that they can be equipped with the tools and empower them to become the advocates, or become advocates for their children. We know as a parent, and we know parents make the most meaningful difference in a kid's education. And as parents, we are willing to do whatever it takes, right, to access the best environment for our kids. Because I want my child, my son and daughter, to thrive. And so I will do whatever it takes to make that happen. I have met in this capacity working with the grassroots organization, and as a parent, I have met many families where school choice touched their lives in some way or another. And I have seen the impact through the lens of an advocate, a parent, family, and even friends. So, when we talk about school choice programs, which we'll, get into, these programs significantly expand these opportunities and options for families that may not otherwise have that opportunity. At H-CREO, just to give you some information as to the work that we're doing in Florida, we know that there's no question that we all want our kids to have a great education. I think we all agree on that. And, school choice is a big part in making that happen for many families. Yet there are still barriers, and some of these options are plainly limited for many families. And, they're limited for folks that can't afford to enroll their kid because of financial limitations in a school of their choice, say a private school. Or maybe they're, to meet a particular, more specific need that particular child has, or sometimes even the neighborhood school is one that is failing the student. And, if affluent parents have choices, why not your most vulnerable and disadvantaged communities? And so in Florida, we have the most robust school choice program, and programs like the Florida Tax Credit Scholarship. It's one of the few programs that provide low-income families with education alternatives, learning alternatives for their kids. So in the case that I just talked about, where the child is assigned, let's say, to a poor performing school, or it doesn't meet the child's particular needs, that program allows them to explore other options. Programs like the Florida Tax Credit Scholarship, they continue to lead the nation with, I'll tell you, 78,000 students enrolled in the 2015-2016 school year. So these numbers demonstrate that parents are desperately seeking these options. The numbers are there. They desire the programs. And in Florida, I'll give you the makeup of the students that are in the program. And I'll go through these numbers. 38% of the scholarship recipients are Hispanics. 30% are Black. About 24% are white. About 3% identify as multiracial. But the average household income, it's $25,000 a year. And, these families or scholarship children, 58% of them come from single parent households. So as you can see, the majority of the children that are using the programs are minority students from subpar communities. So this is important, and I'm glad that Javard mentioned the importance of, we're having these conversations, and this is an issue not just in the African American community, but in the Latino community. And basically, it's an issue that involves everyone, right? But we tend to see that we have a crisis, especially. I want to talk very briefly about the Latino community, because right now we are on the cusp of a new era in America. Latinos are projected to make up a quarter of the population by 2050. And right now we are the largest minority in the nation. We're at 55 million Hispanics. They constitute about 17% of the population. And we're growing at explosive rates. But yet, you know, Hispanics are undereducated. They have the highest dropout rate out of all groups. And I'll give you some stats about Florida. Florida has showed that only 50% of the Hispanics, 10th graders, pass the reading test. Nationally, only 60% of Hispanic students in the 4th grade are considered proficient in reading. And, you know, this should alarm us all, because what's going to happen is that the education system is not conducive to breaking or ending the cycle of poverty and inequality. And if we're not training or finding quality education that meets the child's specific needs, these children are not having access to the 21st century skills that are needed to be successful in today's increasingly digital global economy, then they're going to enter the market unprepared and with a severe handicap. And so this is an issue that's, of course, that I feel very passionate about. In Orlando, and I'll give you an example of a school in Orlando. And as to why these options are important, right? Because it's not a cookie-cutter approach. It doesn't, you know, one size is not going to meet everyone's needs. Not everyone learns the same. But I'll tell you, in Florida, there's an influx of Hispanics, especially in Central Florida. There's an influx of Puerto Ricans fleeing the island. And certain groups have their own unique needs. But in Orlando, there's a school that embraces innovation. And I say embrace innovation because they are working with a group, and they're a small school, they're working with a group of students and parents. And we feel, and, you know, families are probably drawn to the school because the faculty speaks their language. They're treated like family, and they're culturally sensitive. They offer, to the non-English speaking parents, they offer English classes. And for the kids, that are in the program, some of them are already behind when they start their program. And so they offer like the one-to-one help time for students. And out of 239 students, 199 received the tax credit scholarship for low income, and 95% are Hispanics. So I thought it was, I wanted to bring that up and just engage in a meaningful dialogue. And thank you. My time is up, so I thank you for being here. Well, did I say?
Thank you. Well, as Gerard mentioned at the start, 26 years ago, I was lucky enough to be the kid chief of staff to Governor Tommy Thompson in Wisconsin when the first modern private school choice program was created. I got to watch Governor Thompson, a Republican, work together with Representative Polly Williams, a Democrat, and go out and collect votes from both the Republican caucus and the African American Democratic caucus to pass through two Democratic houses of the legislature the first modern private school choice program. And as a young 20-something, I was convinced that this idea would sweep across the country like wildfire. 16 years later, there were only 7 states in the country that had private school choice programs, and nearly all of them followed a different recipe of mostly focusing on a Republican legislature with a Republican governor in order to pass those programs. So, and of those 7 states that had private school choice programs, only one was in the South, Florida. And so a lot of African-American leaders in the school choice movement suggested that we should focus more of our resources on the South and try to reassemble that original coalition that we had in Wisconsin of Republican and African-American legislators working together to try to increase educational opportunities. The assumption behind that, or one of the assumptions behind it, was that support in the African-American community for school choice is very high. In fact, in most polls around the country, It is 2 to 3 to 1, 2 to 1, 3 to 1 support in the African American community for private school choice. Here's some numbers from just last year from 3 different southern states where people 60 years before signed the Southern Manifesto with, for example, in Tennessee, 3 to 1 support for private school choice. Today, there are 23 states in the country that have private school choice programs, plus the District of Columbia. And the greatest growth has been in southern states. In fact, we've gone from only one state in the South that signed the Southern Manifesto to every state that had signatories on the Southern Manifesto, except Texas, has now passed a private school choice program. But the coalition that we hope to assemble of African American legislators working side by side with Republican legislators wasn't as strong in every state as we would have liked. In some states, the support was strong. In states like North Carolina and Louisiana. In Louisiana, the author of the bill was an African American legislator. The same was true in other states. In Florida, at one point, 1/3 of the African American Democratic caucus supported the expansion of private school choice programs there. In other states like Tennessee, Georgia, Mississippi, some members of the African American caucus joined with Republican legislators to get that done. In other places, like in Virginia, just one, and in Alabama, not a single Democrat, not a single African American legislator ended up supporting the private school choice program in that state. Part of that is because of the sad legacy of the Southern Manifesto and of a massive resistance. I had a chance one night to sit down with a legislator in Mississippi, a younger African-American Democrat legislator who said, I'm for charter schools and you're getting me close on supporting private school choice, but you will never get the dean of our caucus to support it. You will get a history lesson if you sit down and talk with him. And that happened, and it's true. Here in Virginia, when the battle just began in that state in 2011 to try to pass a private school choice program, the headline in the Washington Post was that African Americans were split in the battle between those who remembered how vouchers were used in the past and those who saw the promise for the future. In fact, in this state, this story tells about a group of African American students from a predominantly black school who went to the Capitol after spending a month learning about the civil rights movement. They went to the state Capitol to lobby in favor of school choice. And one of the first legislators they sat down with was Senator Henry Marsh, who was an icon in the civil rights movement in that state, filed 50 desegregation lawsuits. And he was absolutely opposed to private school choice, and the students were stunned. They assumed that someone who, from the civil rights movement would be in favor. Then later they went to the office of Delegate Algie Howell, also someone who was involved in the civil rights movement, was involved in a sit-in at a lunch counter. He was one of the co-sponsors of the legislation. So two different legislators, relatively similar experiences, but that legacy of the past colors for many people what their position is even today as we try to move forward. Thankfully, the fear that the modern school choice movement would lead to white flight like it did in the 50s and 60s has not borne out in programs throughout the South in particular. These are the numbers from Florida, which Wendy mentioned just a little bit earlier. You can see that about 23% of the students in public schools in Florida are African American, but 39% of the students participating in the private school choice program, getting a scholarship to go to the private school of their parents' choice, are African American. Disproportionately, children from African American families are participating in these programs. In Louisiana, the numbers are even more stark. 44% of the children in public schools are African American, but 81% of the children participating in private school choice programs are African American. And here in Alabama, these numbers are just from the largest scholarship organization in the state. They don't have a statewide reporting by race of these results, but the largest organization in the state says that while 34% of the children in the state are in public schools who are black, 74% of the children who are getting scholarships from their organization are African American. Now, when I was a political science student, long before I went into politics, one of my favorite phrases was from the French Republican leader in the different Republican Party, the French Republican leader of the 1800s in the Fourth Republic, who once said, "There go my people, I must follow them, for I am their leader." And as someone who later went into politics, that thought came to my mind many, many times. I need to get out ahead of that parade because I know where that one's going. Well, we are seeing across the country growing support from Democrats around the nation. In fact, today, as we sit here, 9 different Democratic governors have signed into law or allowed to become law private school choice measures. I forgot to put Montana Governor Steve Bullock up there. Sorry about that, Governor. But two of those governors ended up serving in President Obama's cabinet, Janet Napolitano and Tom Vilsack. And two other of those Democratic governors, Ed Rendell and Terry McAuliffe, were head of the Democratic National Committee. In fact, Ed Rendell was head of the Democratic National Committee and governor at the time that he signed a major expansion of Pennsylvania's private school choice law. There are 14 different Democratic legislative majorities around the country that have approved private school choice bills, including the United States House and the United States Senate. And so we are seeing growing support around the country for Democrats. Not the level that we had originally hoped, but it is growing around the nation. There are a lot of people who believe that school choice and private school choice is part of the civil rights debate of the 21st century. And in fact, just earlier this year in Florida, at a rally attended by more than 10,000 families from around the state, they were regaled and urged on in their support for private school choice in the state by Martin Luther King III, the gentleman on the left with a colorful scarf. So there are a lot of people, things are changing, and we are still haunted by that legacy from the 50s and 60s. But clearly the modern school choice movement has a completely different purpose and has had completely different results.
Thank you. I mentioned earlier manifesto, hashtag manifesto 60, and I want to read one question that I received, and I'll open it up to the entire panel. The first and second panel talked about the history of freedom of choice, that parents used it and it actually led to segregation. Do you believe that freedom of choice today in the form of school choice will actually lead to segregation or lead to opportunity? And I'll start off with the Deputy Secretary and work our way around.
Repeat that. Will you repeat that again, Gerard?
Sure. The first and second panel discussed freedom of choice and how it led to segregation in the South. Will freedom of choice today for parents in terms of school choice, would it actually lead to more segregation or will it lead to opportunity?
So I think you need to define what we're talking about when we're saying freedom of choice. There's freedom of choice in traditional public schools. There's also freedom of choice for privatized education. The Department of Education does not support the movement of federal dollars into private schools. That is a position that we have stood firm on, primarily because the money, wherever the money goes, we also going to enforce our nation's civil rights laws. And if we're not able to ensure and protect our students who are within that school system, we are not going to allow for those federal funds to move forward in that manner. And so we do believe in choice for public school students. We support, through our charter management organization, the development of charter schools throughout this country. We have certain requirements that they must meet in order to ensure a high quality education for our students. We also continue to support our magnet school programs, which are trying to eliminate racial isolation. So, and I mentioned our proposal to increase socioeconomic diversity within our schools. There are other ways in order to promote choice and that type of mobility. I think what we need to focus on is the Department of Education has a mandate for ensuring education opportunities for all students and not just some. And so in doing so, we are looking for the best method in order to provide that opportunity. And if we cannot focus only on one to the demise of the other. And so for our perspective, I think we do believe that there can be provided opportunities through different choice options. And there are different types of opportunities that are provided depending on what choice options you're talking about. Okay. And I'll just end with this in saying that within the Every Student Succeeds Act, there is a prioritization for for socioeconomic and racial diversity within charter schools, as well as in magnet schools. And we also have that priority within ours. If you have those types of priorities that are encouraged within these types of choice options, I think you can help to eliminate some of that segregation that continues to occur, because we do continue to see a proliferation of students being still segmented or segregated within, whether it's charter schools or others, based upon race or socioeconomic status. So I think there's an opportunity on both ends, but I know that I'm speaking for the Department of Education, and our position is that we can promote those choice options in the best way possible for all students through our public schools.
Okay. Anyone else?
Well, go ahead, Wendy.
So, I made a note to myself because to me, it seems as if that is, we're not talking about involuntary de facto segregation. When we're exercising and I'm talking about the specific scenario and the programs in Florida, there is an opportunity that, or this program provides opportunities for students and underserved communities and parents of low income that would not have that opportunity to explore this option. And so I see it as, my opinion is I see it as an opportunity, not, what was the other one?
Opportunity or leading to resegregation.
Well, I look at it as an opportunity where a child would have a chance to thrive. So that's my thought process.
So every academic study I've seen has shown that private school choice programs actually increase integration, and it makes sense if you think about it. We live in a country in which the public school system, students are essentially assigned to public schools based upon their neighborhood. And sadly, in this country, housing patterns are still heavily racially segregated. And so, on the other hand, private school choice programs tend to have design elements in them, like means testing, or like a requirement that a student be attending a failing public school. If you take a look at the racial distribution of income and you take a look at the racial distribution of failing schools in the country, what you end up with is greater opportunities are given to children of color to attend a school other than the one they would have normally been assigned. And as a result, every private school choice program that's been studied for integration study has shown that private school choice increases integration.
I'm sitting here thinking about quality. Offer the opportunity for parents, absolutely, but make sure those options are quality and effective for those children in the communities. And so, if it leads to I believe we have shut down 11 charter schools in Georgia because they were ineffective for parents. They were ineffective for children, and that, I think that's where the focus should be. What is effective and powerful for families, all families, so that communities can rise up, and so that children have the opportunity to move forward in the future.
I agree with the focus on quality rather than governance. Right. That it doesn't matter to me whether the school is a charter school, a virtual school, a traditional public school, a magnet school, a private school. We should let kids go to any high-quality school.
And the parents, I
determined
like
upon
that.
the parents' income.
Yeah, and I liked your comment. I'm sorry to interject, but I was just thinking, whereas, you talked about quality, and so the parents should have a role, right? Because who better than you? You have, kids. Who better than you would know the particular unique circumstances, right? So the parents should really be making these decisions, whichever school it is.
So we've heard a great deal about parents, and we've heard a great deal about lawmakers and the role they play in trying to advance education in the South. We haven't talked a lot about teachers. What role do teachers, principals play? I remember panel 2, Dr. Buck mentioned that there were a lot of black principals and teachers who in fact lost their jobs. And then today there are conversations of, one reason I don't support charter schools is because they look very different, the new teachers, than our old teachers. Is this somehow neo-colonialism all over again? So from your perspective, what role do teachers and principals play in this conversation?
Well, that's probably the first half of that question. I think everybody here can agree on that principals and teachers are absolutely crucial to the success of schools. We know that not only from academic studies, but from our own personal experiences, right? I mean, it's teachers who changed and transformed our lives. So I think we all agree on that question. I think this is an area that those of us in the education reform movement need to work harder at. Because one of the reasons that Polly Williams, who helped create the first modern school choice program, somewhat soured on the idea towards the end, was that she was concerned there weren't more black-led schools. There weren't more schools with high-performing black teachers who were commanding classrooms in those schools. I hear it from people in the charter school movement as well. I think all of us agree that we need to work hard on teacher quality and making sure that there are inspiring principals in these schools. Principal leadership is extraordinarily tied to academic quality.
Anyone else?
I'll add that I know, the department has been supporting, particularly within our budget proposal, we're supporting a lot of different initiatives, particularly Teach to Lead initiatives that will encourage innovation within within the teaching and education profession, increased professional development. We're supporting, we have a grant program that we called Best Job in the World, in which we're trying to change the circumstances within those schools that are serving our disadvantaged and have a high proportion of low-income students to actually make those the best jobs in the world. So you're incentivizing those teachers, the best teachers, to go to those schools in order to provide the high-quality education. So we know that teachers and educators are kind of the backbone of how the education that our students are going to achieve. I think it's important to uplift that profession and not to degrade it in the way that often happens within our society. Absolutely. Kind of they're using the blame game against teachers when they're not provided the necessary support mechanisms to help our own students. So definitely, I think we need to support those efforts to encourage the diversity within the teacher profession. That's, again, something that we are promoting through a number of our grant programs. We recognize the limitations that exist within the teaching profession, and we're working across the board with associations, with our union partners, to talk about that type of, and particularly looking at our teacher prep programs and saying, you know what, we've got to start from the beginning also. Where are they training our teachers? And we have to incentivize our people to go into the teaching profession. I mean, I'm a daughter of a former principal, as well as a university administrator. And I watched my mother grow up. I watched my mother as she was teaching throughout the years, 25 years, and then she became a principal. And as a result of a lot of the back and forth, I never wanted to be a teacher because I saw what was happening, and I admit that to people to say, this is the reality that we face. And I think we need to acknowledge that and say, you know what, teachers need to be uplifted, and this is a profession that is one of the most important professions in our society. We need to treat it that way. And I think that the diversification is extremely important because I know, speaking as a mother of two black boys, that it's extremely important. And I've seen the difference between the expectations, the level of expectations that are given to my 6-year-old when he has a young African-American woman who's teaching him right now versus a non-African-American woman teacher who was teaching him before. There's a difference in the level of expectations. And sadly, that should not be the reality, but it is. And I know that it's also a factor of who are the role models in our classroom and who are they seeing as somebody they can be, like. So I think that's extremely important. I just wanted to reiterate that, the department really believes in uplifting that profession the way that it should be.
I'd like to echo what you're saying about uplifting the profession. Teachers, I spend a lot of time in classrooms in low-performing schools. They work extremely hard, and work extremely hard, and sometimes they're extremely ineffective. And that's a reality. Again, that contradiction. They work hard, but still not connecting with students, not connecting with their passion. So teacher ed programs, in my opinion, need a revolution because these teachers are teaching students that have only lived in a digital world. These millennial learners they have access. The access to information is tremendous, but the teacher prep model does not speak to that fully. Does not speak to the passion. Doesn't speak to the anger that some of these students have, the frustration, the loneliness, the poverty. We have to get beyond just the academic window dressing of our schools and get down to the root of teaching and learning, and how do we relay to a young person that it is your right to learn. You should have that passion to wonder what a newspaper, why that newspaper is going to keep you in the chair. Yeah, that's it. That's that passion that we need to figure out how to reinstill back into teacher ed programs, and then flood the systems with these new type of thinkers.
Anyone else? Okay, well, what we're going to do is we're now going to open it up to the audience for a Q&A. I'm going to look to left side. I know we have some educators in the room and policy people. We've got a question here up front.
Hi, thanks for your presentation and previous panels. But I haven't heard the whole day. Just how do you reflect your accomplishment? And we know that civil rights, we know that some heroes ahead of us, but the problem is, are we having some heroes continue to carry out their dreams? Now, I think recently for the election, somebody from Everest, there's a civil rights leaders, supposedly, I think, but he want to endorse the Trump, which is very racial profiling type of candidate that we don't want. So I just wonder, is there anything that you can really say you have really bring up the future generation, really say your education, whether it's a private or choice schools, whether you really bring up good education so they can really reflect the leadership. Just by the buildings, beautiful buildings, you don't even know first is whether that's cost effective or that is just corruptive to favor the developers, just like Donald Trump.
Thank you.
So I just wonder if you can really address this type of issues so you can really bring up for the benefit of your children.
I like the idea of measuring whether or not our academic performance is good enough based upon how well Trump does at the polls. Hopefully that'll be a sign that, no. I do think that we need to, no matter what model we're talking about, we have to have a higher level of academic accountability. I think there was a time when we thought, that could be done just locally with the local school board. I think that clearly that hasn't been the case around the country, and that we are struggling as a society to look for other ways to do accountability. There was a movement to let's do lots of tests, right? And then there's other sorts of efforts that have been made, and there's been backlashes against those. But we have to find a way to require a higher level of accountability in all the different types of schools we have in the country.
Anyone else?
Well, in response to legacy, I think it's unfair that young people typically have no real knowledge of the Brown cases, no real knowledge of the Southern Manifesto. I'm talking about 16-year-olds. They have no real understanding of the history of public education here, so they can't connect that personal value and that pride to be able to fight for their own options. So I agree with you that even I'm 40. My generation, I mean, I was a Bailey Sullivan Leadership Institute fellow a few years back. At late 30s, my knowledge of Brown jumped up, and I'm in the movement. Right. And so it's not connected to our general learning and the general thinking of young people now, and you're bringing up a good point.
We have two questions. We're going to start here, and to make sure that we can get it as many as possible, we'll go here, we'll have you ask a question, and then we'll cut it off there, and then we'll give everyone a few minutes to respond. Go ahead.
I just wanted to say earlier on the panel, someone said something about the fact that integration brought about changes whereby a lot of African American teachers lost their jobs. And I just want to say from a personal standpoint, in Prince Edward County, Virginia, we had some of the best teachers who motivated us, pushed us, and tried to make us excel. And also they showed their love for us. They were very attentive. And I think that may have been one of the unintended consequences of the integration, because we had such a wonderful set of teachers, and you can attest to that, John. So, yes. So I do think that has been something that may have been negative about the integration.
Okay. We have a question here, then we'll go to the back, and then we'll have the panel respond to anyone they want.
My name's Daniel Rumley. I'll represent Bailey Sullivan, as I was a fellow with Kenneth. The first kind of question is for Ms. House. With the election right now, what do you think about the fact that education is not mentioned in the Constitution? A lot of people wanting to push it to a completely state-driven thing. Secondly, to Kenneth, and really the whole panel, I'm not anti-Brown. I don't want anybody to think that when I say this, but I think I am somebody that looks at Plessy with a different lens, because to the point of that school getting closed down that your mother was educated in and pushing out love before these laws came or these decisions came that forced integration, people had skin in the game. I needed people that looked like me to be successful, and so there was a different level of love and care when the facilities weren't necessary there. So I kind of reject the notion that all black inherently means bad, and that's kind of what I get from some of the scholarly breakdowns of what we're talking about right now. I'm just kind of curious about y'all's thoughts on that.
All right, we'll save that, and we'll get a question in the back, and then we'll have everyone respond.
My question, Robbie Luckett, Jackson State. My question is twofold. From my perspective in Mississippi, opposition to charter schools and school choice is in part about civil rights legacy, but it's also about two things I'd like to hear your responses to. One is, how do we make sure the children who need it the most aren't left behind? Mr. Mason, you mentioned your KIPP school in Atlanta all of a sudden has done so well that there's a new neighborhood and it's now serving children you didn't intend for it to serve. There's a concern that there are going to be children left behind. And two, how do we afford it? In the state of Mississippi last year in 2015, we underfunded public education by $211 million.
Okay.
So how do we afford it? And how do we ensure the children who need it most aren't left behind?
So what we'll do is we'll start with the Deputy Secretary to answer whatever questions you want, and then we'll come and end with Scott. We've got 5 minutes, so we can do it. All right.
I got the point. Got the point. I think that it is unfortunate that we haven't heard much talk within our election about the state of education. I think it's important for all the candidates to be talking about that, and that's why I talked, and I ended my presentation with the importance of voting. So I think it's incumbent upon all of us to raise those questions with all of our candidates. While yes, there is the predominant enforcement for an education rests with the states. The federal government has, a limited ability when it comes to financial, the distribution of funds. That we have a limited resources that we're able to provide. Yet we do have the ability to provide that guidance and oversight and enforcement of our civil rights. So I think that that still rests with the federal government. The goal is to make sure that we're looking out for all students, and I think we're going to continue to do that. Even as we go into the future. The last question, I'll just say that how do we make sure that children are not left behind? I think that's the premise of how it is that the department views the kind of when we're talking about privatized choice education, because we are wanting to make sure that we're looking out for all children, and that's our mandate. And so while we don't necessarily oppose the use of privatized funds in order to support privatized education, when it comes to taxpayer funds and dollars, that we have to be responsible with how that money is being used and ensure that we're also providing a high quality education, as we talked about. And so from our standpoint, that is something that we are fundamentally resting upon in terms of why it is that we only support the utilization of federal funds for public schools.
To clarify about when KIPP Primary opened, and it's outside forces that are trying to change the makeup of that school. But the reason why I believe that it won't change is because the foundation that we established from the beginning, we built partnerships with the neighborhood planning unit there. We have parents that not only founded the school, but they work in the school, they work in the cafeteria, those parents that live in that community are a part of the school. It is a neighborhood school, and so those parents who live there can fight for it, who live there for as long as they can live there. And so that was my concern, that when we see real estate agents, moving in, and now I'm gonna switch to Daniel's point. Now, is that necessarily? Should I see that necessarily as a bad thing? I mean, because, and I'm with you there. An all-black school that is successful. Why? Look in the mirror. Why should I have a problem with that? Why do I have a problem with that? KIPP Strive was 99.9% African American, not by design, but by the choice, choice of the people that went there.
Okay, Wendy, and then Scott in 2 minutes.
And and so I would like to make a comment that parents are not going to be pulling their kids out of the public school system if their child is thriving, and my focus or my issue is kids that are in the public school system. And I'm going to refer to some civil rights data collection from the U.S. Department of Education that indicated, and this is a survey from 97,000 of the nation's public schools, that 57% of black students and 67% of Latinos have less access than their white peers to the kinds of rigorous math and science courses that are needed for many colleges and career. So just going back to your question or comment, this is an issue that all of them are going to be falling behind if we don't fix the system that we currently have. Sorry.
It is my understanding that as of a month ago, in all the presidential debates that we've sat through, there's been one question about education. All those media types, one question about schools. Give me a break.
Yeah.
I mean, it's certainly much more important than half the other crap they're talking about during those presidential debates. So, I mean, I'm deeply disappointed. My kids used to watch the debates with me. Now I'm getting nervous that they're going to hear things they shouldn't be hearing. So we've kind of stopped watching in our house.
Well, the great thing about AEI is we actually have a 5-question series, and so you can go to AEI's website, particularly that for our Education Policy Studies Department, and see the questions that we've actually raised, some of them which have actually been presented to presidential candidates. It's now 5:55. First of all, let's give a hand to our third panelist. What we're going to do next is outside, you're going to find the food. Between 5:55 up until 6:30, you can get your food. You can bring it in here. You can continue the conversation with panelists and with others. At 6:30, I'm going to have a conversation with Cheryl Brown Henderson. And before we begin, then I'm going to bring up Bob Moranto from the University of Arkansas, who's partnering with us on this event to talk about the role that scholarship's going to play. So it's time to eat, and thank you, and look forward to seeing you at 6:30.
This was good, man. Thank you.
You're staying, right?
I've never seen anybody moderate like that. 5:55 and you cut it like that? How did you do that?
That's right. Don't worry about it. That's fine.
Yes,
Thank you.
you spoke
Thank
to
you.
you spoke to our
Bailey
group.
Sullivan
Yes,
thing, right?
yes, and caused a ruckus. You caused a ruckus.
Then you guys went out bowling.
You
or something.
caused a ruckus, yeah, because you know it was with Dr. Fulton,
Right.
because in my mind I was like, no, that's not. And he looked at me, he's like, you fight for the option. You don't fight for what you think it looks like. If you're a parent that has the means, and I just had to like sit down and absolutely so it's open.
I just heard that there's no more food left. Get out. Go eat. Go eat.
I hit a wall at about 2 o'clock today.
No.
I went home, I played 3 hours. And I had to drive. Yeah, I go to Richmond, right? better parties in Louisiana. So we have better parties in Louisiana.
Oh, yeah. No, that's, oh, you mean better parties. Oh, all right. Now I'm gonna get crazy parties. You know, bands just like copycats.
All right. See, I we have one principal. What about yourself? One more. Yeah, let's see if I can get it.
Oh, that's good. That's a good picture.
What if we get a move?
I just read this week. Oh, no, you have a question from California. You can do that. I'm disappointed today. All right, let's tonight.
If everyone could take one step to their left, it looks like.
Everybody take one step to your left.
Yeah, you should be good right there. All right, and try to get as close together as you possibly can. Yep, you're good right there.
I think I had
All right.
Big
somewhat
smiles.
misunderstood.
All right, ready? In 3, 2, 1. And one more for safety. 3, 2, 1.
Hold on 1 second. Amy,
Wait.
Oh yeah, always be digital. Can I make sure you
Push your shoulder in there more, and then you come in this way, sir. There you go.
Thanks, David.
This will be my Facebook cover.
Did you all get cookies? You did, right? Did you get
Can you help me with
All right, Sammy, you want me to?
Okay, so I was. She's gonna grab it from there.
Yeah, probably not.
Okay.
This could really go bad. Right.
Check 1 2. Lavalier, check 1 2. Lavalier, check. Lavalier, check. Lavalier number 2, check 1 2. Lavalier 2, check 1 2. Lavalier 1 2. Lavalier Mike, check 1 2. Lavalier Mike, check 1 2. Check 1 2. Check 1 2. Check 1 2. Number 5, number 6.
Send me a note. I have another email. Okay. You sit there in the corner. Anything more than a month is likely. No, I can't keep up. I probably could pull it out. I have a 216 number, but that's fine. All right, we'll make it happen. No, not that early. Plane is leaving. I think I leave at noon, but I don't want to get caught in traffic because I realize with all the people coming in and out because of the ACC, and if I miss that flight, I am done. So, as you continue to eat your dinner, we're going to start the one-on-one conversation soon. But before I do that, I want to bring up a colleague, Dr. Moranto. He is partnering with the Education Policy Studies Department to work with this, and he's going to talk to you about the role that scholarship will play in this. And so I'll let him tell you more.
Thanks, Gerard. I always go on and on, so I'll make it really quick. I'm Bob Moranto at the University of Arkansas Department of Education Reform. We have a wonderful PhD program in education policy with great fellowships, and our graduate students are incredibly successful. In fact, Malachi and Stuart, can you stand up? Stuart got his degree from us, I think, 3 years back now. Malachi will in about 3 years. So if you know anybody looking for an ed policy PhD, we're the place. I also edit the Journal of School Choice. I've got a few copies up here that I'll leave out, folks can get. A number of you have made, actually every talk today was great. A number of them were very good scholarly presentations. I know one, in fact, has already been in the journal a couple years back. If you would, we are going to do a special issue on the Southern Manifesto, the 60th anniversary, and what it says about school choice today in all kinds of ways. And I hope a lot of you will submit your talks as part of that. If you want to, excuse me, I've got a little set of things here for instructions on how to do it. I'll also fill out everybody an email, and I'll leave copies of the journal up here. I'll be around the rest of the evening, and I hope we can have a conversation on that. And thanks again to everybody. My own kids did not know what the Southern Manifesto was, so I will. It's something we don't teach very much, and we really need to. And I'm going to have a conversation with them this weekend. So thanks very much, Gerard. Thanks.
Okay.
We have 5 minutes. We're good. Testing 1, 2, 3. Did you finish?
Yeah. I believe mine's on. It's on. It's just. we ready?
Yep. So as everyone is enjoying their meal, we are now toward the dinner conversation portion of today's event. Professor Robinson. Thank you, Professor Robinson, from the University of Richmond School of Law. I should talk to your dean about this. So we are now at the dinner conversation, which I know many of you are ready to hear. We've had 3 panels thus far. One that looked at the Southern Manifesto as law and language and the past. We had a second panel where we looked at Southern Manifesto and what did it mean for state education policy, Georgia, Mississippi. We also had a national, not national, but a broader overview from Dr. Buck, who mentioned North Carolina and a few other places as well. And we also had, of course, had Virginia. And then we had our last panel where we had a conversation about lessons from the past and where do we go to the future. But it's going to be tough to really have a conversation about the Southern Manifesto without having a conversation about Brown v. Board of Education. And as we mentioned earlier, there's someone I'm sitting next to now, Mrs. Cheryl Brown Henderson, who knows a little something about the Brown case and the Brown family. And so for the next few minutes, and then we're going to have a Q&A later on, we're just going to have a conversation. She was kind enough to sit throughout the entire event. She also brought family members with her as well. And so we're going to have a conversation. I think it's important. So first thing I want to say is thank you for being here.
You're welcome.
Is your first time to AEI?
It is.
So welcome to AEI. I believe Mr. Stokes mentioned a book called Simple Justice. When I was a graduate school student, this is one of the 10 required books I had to read on the history of Brown. And there's a young black girl standing in the middle of 9 black-robed justices. Who's the girl right here?
The girl on that photo is my sister, and we'll talk about that as the discussion unfolds, I'm sure, about what perception that created.
So, who is Cheryl Brown Henderson, and what is the Brown v. Board of Education Foundation?
Well, thank you for asking. First of all, I do want to thank you for the opportunity. I've certainly learned a lot today. And what I was most impressed by was the passion and how people believed very deeply in their presentations today. The research that you've done, we've learned a lot, but it also gives us hope. You know, it gives us hope that people are continuing to recognize that we're not there yet, and that those of you that presented today, we are in good hands, that you're doing the hard work, you're doing the research, you're formulating the policy, you're lobbying when necessary, and so we have to believe, even though it's not part of the current political discourse, we have to believe that there's hope. So I do want to begin by saying that. I also want to thank my fellow Brown v. Board of Education families, as we call ourselves, for coming today. People from the Virginia case and from the South Carolina case. I have been so fortunate and privileged to get to know most of them over the last decade. And last May 16th, we were all together at the White House. 62 people from the 5 cases came together, as well as Mrs. Marshall, widow of Thurgood Marshall, one of his sons, and Charlene Hunter Galt and others. But I bring that up because it was so profoundly moving when the president finally arrived and walked into the room, and you have 62 people standing there, plus the NAACP Legal Defense Fund Board of Directors, plus other people, Deval Patrick, and you could have heard a pin drop. And he looked around the room and he said, "Thank you." But secondly, he said, "Look where we are now." And everybody, I mean, it was a tearful, it was a hallmark moment in so many ways, because people understood, you know, here we are, an African-American president, and the folks that sacrificed, many of them, quite a bit in terms of sacrifice to get him where he was. So forgive my editorializing. So Cheryl Brown Henderson. My father was Oliver Brown, for whom the consolidated cases are named. So the legal citation is Oliver L. Brown et al. Versus the Board of Education of Topeka, Kansas et al. And the et al. Includes Briggs v. Elliott and Bowling v. Sharp and Belton Gebhardt, Beulah Gebhardt, Delaware. It includes Davis v. Prince Edward County. It includes 4 cases plus Brown. And I take a great deal of pleasure of traveling around the country, talking to groups about the consolidated cases, because most people stop at Brown v. Board. They don't even put the Topeka on it, and they certainly don't put the Kansas on it. But I take great pleasure in informing people and making people aware. One of the young men said earlier that at high school level, even early college, this is not the kind of discourse you're engaging in. It's not what you're learning. It's not what you're analyzing. It's not really part of your foundation, and it should be. And I know a lot of state standards, for states that do have education standards still, Brown v. Board is a required subject, and we're very pleased about that. However, we are concerned about how it's even being taught. Is being taught comprehensively? So all of that comes into play. So in 1988, my family, which consists of my mom and my father died in 1961 at the age of 42. I was 10. So he has been gone a very long time. And of course we wonder, what would he think now? And how would he interact now with the folks that are sitting here in the room, and what his life would have been like in terms of social activism had he lived. But I bring that up because in 1988, it was kind of the last stand. And I gathered my family together and said, we have to stop allowing this to happen to us. We need to manage, take responsibility, and become good stewards of this history. Because every 5 and 10 years when there was a national anniversary, the press would converge on our city. I'm sure the litigants in the room today had the same experience. It was happening to us. So we made a conscious decision to organize, and in 1988 started the Brown Foundation for Educational Equity, Excellence, and Research. Part of the research was finding the other et als. I don't like that term. And I know the legal community and attorneys in this room certainly understand it is a convenient term, but it's brutal because it buries so many people and it obscures so much sacrifice when it comes to Brown v. Board. The et als, that's hundreds of people in those 4 little letters. And so what we try to do is to unearth that et al. And to give names and faces. And the PowerPoint that I use with my lectures, it's a photo of everybody. I go through each of the cases and talk about their circumstances and let people look at who they were, including the full legal team. We stop at Thurgood Marshall, and if you know Jack Greenberg, you stop there, but there's so much. Brown is multi-layered, it's very complex, so we took on the responsibility in 1988 of starting an organization that would allow us to research, to locate people that were involved, to make their acquaintance, to create opportunities for them to speak and write and be known, and then to come together several times a year to develop curriculum, traveling exhibits, other resources that if you go to our website at brownvboard.org, you'll discover. One of the other challenges, which is the reason I plugged our website, is almost weekly, somebody will come up with a new web edition, their summary of Brown v. Board, and 99.9% of what's on the internet is absolutely false. So we make it our mission to, as much as possible, work with History Day students, university students, K-12 system, to get curriculum to the hands of those teachers, to make certain that the comprehensive story of Brown v. Board is being shared. And what you mentioned earlier, that analysis and that understanding can take place.
You mentioned research and the importance of history. We celebrate Brown every 5, every 10 years. What keeps you encouraged about where we are with conversations about Brown, and in particular, what 2 or 3 things from today's conversation about the manifesto, which you mentioned to me, very few people talk about?
Well, first of all, we don't celebrate. We commemorate. Brown is something that you want to note. You want to commemorate that happened. There's not cause for celebration. Don't know that I'll live that long. But I think it's important that we commemorate it so it's not forgotten. And so we can remind people, as the panel did today, that it continues to resonate. You know, yes, we are still struggling with equity in public education. Yes, we are still counting heads wrongly. And I do agree with the young man that stood up earlier that said that in all African American anything is not bad. And in all Latina anything is not bad. We shouldn't get distracted, because what our K-12 system is charged with doing is first and foremost educating, not counting heads. So let's let the policymakers and the courts worry about, you know, what desegregation looks like. But let's not allow our educators to become distracted by that and stop educating. And I worry about that, which is why I agree with you that it shouldn't matter the color of your student. What should matter is what your job is and what the expectations and outcomes must be. So I do appreciate your saying that. The panel, I think, brought home, you know, so many things. I love the comportment of the young lady from the U.S. Department of Education. She was undeterred, and I loved it, because we have to recognize that we've put money together collectively. We have pooled those resources, and I do not like any suggestion that we could have failing, underfunded public schools. The public has more money than God herself, excuse me. So how on earth do we say that with conviction? How can we even say it with a straight face? So I worry about that, and I listen to the idea of giving options, private charter, public charter, whether it's simply options in choice of public school issue. I believe in that, absolutely. Because what we're all trying to do is make sure we don't lose more generations, because we've lost way too many. So I hats off, you know, so I'm not gonna guilt trip anybody. I'm not chastising anybody. I think we all have a role to play. But let's not forget that those of us who pay taxes, that have pooled those resources for the express purpose of the collective good, you know, need to make sure that those resources are being spent in a way that our children are being educated, that our schools are the best. You know, I don't know how you walk away from a school by saying, oh, it's not working. It's failing. It's underfunded. Excuse me? You know, who has the responsibility? We have the responsibility of circling back. Now, we go to great lengths to train our military officers. You know, I live in Kansas. Fort Leavenworth is out there. I live next to Colorado, where one of the military academies are. You know, why are we not going to those kinds of lengths to make sure we are training our educators, our administrators? Because bottom line, folks, without teachers, there would be chaos, you know? We have done such a disservice. I was glad to hear that on the panel, about how we don't acknowledge, recognize, applaud, laud, you know, our educators the way we should. No doctors without educators, no architects without educators, no engineers without educators, you know? And we're talking about all kinds of education.
Sure.
So we at the Brown Foundation consider the trades, we consider vocational education equally as significant as that PhD. Because the PhD didn't put the carpet on this floor, didn't put the walls up in this building, didn't wire the lights. So we have to recognize, and there's no room for arrogance, okay? So recognizing all of those things, which is, I was so pleased to see the panel touch on a lot of that. But I also realize that we're here to talk about the Southern Manifesto, which is, again, something that I take great pride in educating my audiences about, because most people are not aware of that pushback on the part of our elected officials. And that one of those folks that signed the manifesto clearly didn't author it, but was in Congress and the Senate for many, many, many decades. I ran into Senator Thurman in the tunnel one day when I was working the Hill, and he was being propped up by a couple of able-bodied men, and he was still there, still lucid, still functioning. But it struck me then and there that the public stance of being a segregationist belied the private life of some of the folks that we are now more aware of, you know, what happened when the lights were out, so to speak. But, you know, I say all of that because I think the Southern Manifesto is a clear example of what's going on now. You know, there are all sorts of buzzwords and phrases, and when people start talking about states' rights, which is what the Southern Manifesto asserted that it was bolstering and making sure they didn't get left in the dust. But anytime our political leaders begin that kind of dialogue, I worry. Because it was when we were living in the era of states' rights, during the pre-Brown era and shortly thereafter, that African Americans were most at risk, that our lives were most at risk, that our freedoms were most abridged, if you will. So I worry about that kind of talk. But the Southern Manifesto, by its very nature and the fact that it exists at all, coming from an elected body that's supposed to represent all of us, you know, reminds me of the political discourse today. Take our country back. Who took it? You know, I want my country back. You know, we've been hearing that for the last 8 years, and nobody has yet answered back from where? You know, who hijacked it? How is it looking different than it looked before? You know, I won't answer that because you already have your answer. But I think that the Southern Manifesto, to me, smacked of the same reasoning, that the Supreme Court was taking their country. You know, meaning that African Americans were going to have to be looked on as equal citizens. We're going to have to be treated with all the rights and privileges of the Constitution. It's not the country the Southern Manifesto authors intended, nor is it the country, I believe, some of the rhetoric that says, I want my country back, intends. So I think when we talk about the resonance of the Southern Manifesto and the resonance of Brown v. Board of Education, it is just one big old historic continuum. And for those of you in the room who are young and are now on the scene, because those of us that are looking to retire to Florida, kind of slow down, be a full-time grandmother and all that kind of good stuff, you know, you've got to be aware of that. Coming to these kinds of meetings, doing what you're doing in terms of sitting on boards of education. We need you everywhere. We need you running for office. We need you at AEI. So I think that today, if it didn't do anything else for those of us who are who were active back in the day, and I won't say old heads, although that's not a bad term. You know, I think it really makes us recognize that some of the young people did get it, and that we can go off and drive our golf carts, you know, with some certainty, you know, that knock on our door when you want a little reminder. But I think it's clearly understood, and you do get it. So hats off to AEI, absolutely.
You mentioned private life. You also mentioned family. When we read this book, when we watch TV programs, I was sharing with the Johns family, one brother, the first time the Johns family had come to my attention was watching a TV show, it would have been in the 70s, when James Earl Ray played Reverend Johns. And then I moved to...
James Earl Jones, not Ray. Yeah.
Oh, no, yeah, wrong. Wrong person.
We'll edit that out.
Yeah, no, that's live, so it's on there.
Oh, no.
But you know where my heart was going. And then I moved to Virginia, and then I hear more about the story.
Yes.
One thing that's often missing in this conversation, the impact on families. I mean, people had to make a conscious decision to say, we are going to sign our name to this case. What it did to fathers, what it did to mothers, families, Briggs having to move from South Carolina to Miami, back to South Carolina to New York. Let's talk about families. What was your family thinking at this time?
Brown is very family-centered. I'm glad you mentioned that, because we always talk about the NAACP attorneys and the families that stood with them. And we talk more about the families that stood with them so people will know who that et al. Is. Family. Well, the other interesting thing about Brown, and I'm going to circle back to family, is that the misnomer of how all of us got involved. And that's how the internet has done so much harm. Because one of the misnomers is, first of all, that Brown v. Board is it. You know, there was no Briggs and Bowling and Davis and Belton and all of that. That's number one. So we try to refute that because, of course, we all know that not to be so. Secondly, the misnomer is that Oliver Brown, my father, on his own, you know, made some sort of compelling decision that he was going to sue the school board on behalf of my older sister. One website suggests that he went to New York and sought out Thurgood Marshall. My father never met Thurgood Marshall, suggesting that he came back from World War II with this new fire in his belly and I'm not going to take it anymore. My father was born with an enlarged heart and could not serve in the military. So there are all these, one misnomer is that our family was chosen, and Brown was chosen as the lead case because we were the only intact family. Everybody was a mom and a dad and children. So all of these myths have emerged. I think of Brown in terms of myths, challenges, and unanticipated consequences, some of which we've discussed today. But this is how we got involved. First of all, Kansas. And I won't ask, because I already know the answer, to how many of you have been there. And, well, then I have to do it. Did you stop? Because most people don't spend time there. Okay. They claim they've been there if they've driven through. You know, that doesn't qualify. But Kansas is a unique state and is uniquely suited to and situated to the civil rights history of our country because of Bleeding Kansas and the fact that John Brown, whom I believe was divinely inspired and not crazy, was able to halt the westward expansion of slavery at the border of Kansas. Kansas then took on a whole different demeanor and actually actively recruited formerly enslaved people from the South to come live in Kansas, promising certain freedoms and land and opportunity. But when people took them up on that offer by the thousands, then the benevolent folks of Kansas said, wait a minute. Now, what are we going to do about public education? You know, it became an issue in Kansas as well. I'm telling you all of this because as early as 1881, African-American parents in Kansas began taking this notion of segregated schools to court. There were 11 school desegregation cases in the state of Kansas prior to Brown v. Board of Education, like no other state in the country. So the little state that you drive through, excuse me, you may want to spend a minute there next time. So it's been supremely important, and I take a great deal of pleasure telling people about that because the Kansas law basically said that if you were a city of 15,000 or larger, you could have segregated schools, but only at the elementary level. So that meant in the entire state of Kansas, legally, there were segregated schools in Wichita, Kansas City, and Topeka. The rest of the state was too small to legally have segregated schools. They didn't meet that 15,000 population benchmark. So a lot of those early cases from 1881 to 1949 were successful in state Supreme Court because they were illegally segregating. There were 3 cases in the city of Topeka before Brown v. Board that were not successful. So this was not anything unique to the state of Kansas. It was not something all of a sudden to African-American people in Topeka. So when the NAACP in Topeka started working on this 12th challenge, the difference was they decided that they would go to federal court. They would not simply stop at state Supreme Court. So they began working on this in isolation of South Carolina and Virginia and Delaware and Washington, D.C. Joined forces, of course, when the Topeka folks with the NAACP wrote to the national office in New York for help. That's when they were made aware of the other cases that were being formulated and developed in the cities that I mentioned. So how my father got involved when he mentioned family. My father was good friends with one of the attorneys for the NAACP, Charles Scott. 2 of the attorneys in Brown and Topeka were brothers, Charles and John Scott. Their father, Elisha Scott, was the patriarch of the law firm. He had been the attorney for the Negro baseball leagues that you all have heard about around the country, and there's a museum in Kansas City that talks about them. Elisha Scott was the attorney for them. He was also the attorney for the African Americans who came out of the Tulsa race riot. So Elisha Scott was a busy guy, basically. So the sons followed his lead, became attorneys. Charles Bledsoe, their partner in Brown v. Board, was a firefighter in a segregated African American brigade. He read for the bar. He did not go to law school. So he joined their team. Those were the three legal counsel on the ground in Topeka. But anyway, long story short. So the NAACP in Topeka, led by McKinley Burnett, decided they were going to try this again, but they needed plaintiffs. And they were going to make it a class action always. It was never going to be a single parent, which is why this falls flat, that you select one child, one family. It was never the case. So they go door to door in the summer of 1950, asking neighbors, friends, fellow church members if they would sign on to become plaintiffs in this case they were putting together. So Charles Scott, my dad's childhood friend, came to our home on a Sunday afternoon and asked Dad if he would be willing to join this roster of plaintiffs they were putting together. But when my father looked at the list, by the time they got to our home, there were 9 people. Dad was number 10. We're all women. So my father said, wait a minute. I don't know that I want to get involved right now. Are you going to be recruiting other men? I mean, let me think about it. My mother was pregnant with me, and back then pregnant women didn't go out and about. It may have been all women had that been the case. So my dad thought about it several weeks. Charles came back, and Mom then worked her magic, convinced him that this was the thing to do, and he said yes. So by the fall of 1950, there were 13 families who were the plaintiffs in the Topeka case of Brown v. Board. They were told to locate the closest white school to your home. We didn't deal with those schools. They weren't on our radar. We weren't worried about going to those schools. They were just there. And you locate that school, you take your child or children and a witness and attempt to enroll. And then you come back and tell us what happened. So that's how we got involved. So all over town that fall, my father with my sister, the other moms with their children, and witnesses tried to enroll at all the different white schools around Topeka. There were 22 elementary schools in Topeka, 4 for African American children and 18 for white children. And if you lived close to one of the white schools, which we did, you couldn't attend there. You had to go to the school you were assigned to. And in our case, it was just a 15-block bus ride. Everyone rode school buses. The longest ride for one of the plaintiff children was James Emanuel, had a 33-block bus ride on a city bus because it was outside of the area for the school bus. At any rate, so we got involved in a very simple manner. Dad was not a crusader. My parents were not activists by any stretch. They were simply raising their children. My father was in seminary. He became a minister in 1953, so he was not a clergy, which is another misnomer, that they chose Brown because Dad was a pastor. That's not so. Anyway, so just in a very simplistic way. So once the parents signed on and attempted the enrollment, were denied, came back and reported in detail what happened, NAACP had the documentation they needed to file. February 28, 1951, when they filed Brown v. Board, is when it became known as Brown v. Board. My father was not first alphabetically, another misnomer. Darlene Brown was first alphabetically because D comes before O, and they were equal. So we believe that it was either the clerk of the court or a legal strategy to list him, have a man, to be the head of the roster for the Topeka case because he was number 10, not number 1, and all of those things that people have been told over the years, and sadly our textbooks recount, are not true. Because our textbooks would tell us it was all about a little girl, who went to a really bad school, and she was trying to get to the neighborhood school, and she was black and couldn't, and so her dad was angry, and it's a cute story perhaps, but it just has no grounding in fact whatsoever. Briggs v. Elliott was first on appeal, which Congressman Clyburn and Nathaniel like to remind us of. Brown came later. So when Brown reached the Supreme Court, a couple of things happened. First, when Brown was heard in the lower court, in federal district court, the presiding judge of that 3-judge panel, Walter Huxman, had been the governor of Kansas before he was appointed to the federal bench. The expert witnesses were a psychologist, Louisa Holt, from Meningers, which is part of Topeka's legacy and history. And it was Louisa Holt who talked about the psychological harm, absent the Mamie and Kenneth Clark Dahl test. That all converged later, but she talked about that harm as well. Hugh Spear, who was a teacher at an area community college, was a person that surveyed the buildings and found the buildings to be appreciably equal. Because in our case, it was not about buildings, it was not about buses, it was not about quality, it was not about money, it was about principle. That's how, when Brown reached the court on appeal, it's our understanding that although Briggs arrived first, that the court saw this as an opportunity. Kansas was a border state. We were not back in the North and South debate anymore. And Kansas was filing simply because it was a principle, a matter of principle. The African American educators held more advanced degrees than their white counterparts because there was no place for that master's or that doctorate. You stayed in that elementary school and taught. So we weren't talking about a bad education. The same gentleman that built the white schools built the black schools. They were all lovely brick buildings. He liked fireplaces in his buildings. The kindergarten rooms had fireplaces in them. So it wasn't about that. African American children rode school buses. So we weren't talking about the right to have a school bus to get to school. But we were talking about, I pay my taxes. There's a school 4 blocks away, but I have to wait until you assign me to a school based solely on race. So that was the only thing Brown brought uniquely to the table beyond the cases that I mentioned. But I do want everybody to understand that my parents simply had an abiding belief in what this country said it stood for. You know, African Americans never viewed themselves through the lens of the conditions that were forced on us. We viewed ourselves through the lens of what this country, the promise that it held. Otherwise, we wouldn't have fought this country's wars. We wouldn't have worked so hard to bring about the cases that we're talking about right now today. So living in the margins was not acceptable. And yes, we did lose some things in integration, but we gained the ability to step outside of that bubble without fear of having our lives taken without repercussions. And that's why, you know, the last couple of summers have been so painful.
Another misnomer that I heard as growing up, kid, adult, brown was chosen because brown also happened to be the color of skin.
Well, that's a good one.
And that was a good one to use. So what I'm going to do is we've got some time. I want to open it up for questions. I know many of you are here to not only hear from her, but you may have some particular questions. I'll start on the left and see if there's anyone here, and if not, I have a group of other questions that I could ask. Anyone at the back of the Bailey Sullivan table? Any question? Okay. Question at the back.
Thank you, and thank you for being here. It's an honor to be with you and all the. In Arkansas, we call y'all the foot soldiers of freedom, so it's very honored to be in the same room with y'all. I do have a question, comment first, and then a question. I tend to agree with you, I think, about the need for public schools. James Madison had it right 200 years ago when he said that popular government without public education is either a tragedy or a farce, perhaps both. But my concern is that and I was in seminar with the legendary Bob Moses one time in 2011. He pointed out the fact that none of our presidents, when they come into Washington, D.C., they place their kids in public schools. They all put them in private schools. President Obama, our current political debate, both sides of the current political debate, they're talking about public education, and yet they're putting their children in private schools, and they're products of high-powered private education. All of our Supreme Court nominees are products of private schools and elite private education. Our congressmen and congresswomen, they do not use the public schools of Washington, D.C. How are we ever going to establish and get public support for our public schools when our leaders do not practice what they preach? Is it possible for us to have a quality public education system? And how can we influence them to recognize that? Thank you.
I'm glad you brought that up because I know, as you mentioned, the Phillips Academies and the Andovers and all the places that our leaders have come from, and having the opportunity to have those exclusive private educations that oftentimes are placeholders. They are kind of a pipeline, intended for that leadership. We don't look to our public school system for that leadership. And somebody asked that question and mentioned it earlier in one of the panels, I think, talked about, how do we get that leadership from our K-12 system that's funded publicly? And that is one of the challenges. I think that's also a very good place to take the debate, is leadership from that K-12 system that's funded publicly. If we're talking about public leaders, why aren't we making sure that there is a track at some point, if students express that interest, where we are grooming them, as they are groomed in that private system to become this country's leaders? You're absolutely right. The only answer is that. And getting the public to speak in one voice is very tough. This is the thing. Every president we have sets an education agenda. Now, I became aware of that when I was working for the State Board of Education in Kansas, and I read grants for the New American School Development Corporation under President Bush the First. He was going to reinvent public schools. We're reading these grants, and the Edison Project, and many of you have heard of that, and all the different people that we were going to fund to help realign, repurpose, create a new system for public education. And then you think about President Clinton, who decided we were going to use federal resources to shore up the infrastructure of the crumbling public schools. And then we have, I circle back a minute to President Bush the First, which also talked about pre-K and parents as teachers and some of the things that did work and that we still are doing. And then you think about President Bush the Second, who talked about no child left behind, but my joke was always, he's not looking behind him. And then you looked at the current president, the race for the top, and some of the other acronyms. But every president sets an agenda. This is my concern. Why, when every president comes in, do we have a changing of the guard at the U.S. Department of Education? Why isn't that a senior executive level position that stays in place so that whatever policy, whatever idea, whatever research-based programs that come into play have time to play out? They don't have time to play out when every 4 to 8 years there's a brand new one. And everybody on the ground is jockeying to adjust to that brand new thing. So when this group of teachers in schools have finally figured out, the key to no child left behind, well, it's time to race to the top, So that worries me, that we don't value education enough to give it some grounding, make it a constant, so that the kind of discussion you're talking about, so we can talk honestly about where these leaders come from and talk honestly about why aren't we doing the same thing and grooming leaders, public leaders from our public schools. I do want to make one other comment aside from that. When somebody asked about the Southern Manifesto, and we talked all about white subscription, and buy-in to the Southern Manifesto. But what we didn't talk about is how it motivated African American resistance. I think the Southern Manifesto was huge in getting Black folks to take to the streets. When it became clear to us that Congress, was not a body that had our interests, even though in some places where we could vote, we had voted them in, it became clear to us that activism, democracy is messy. And the only way it works is when those of us on the receiving end insist that it work. When you think about Black Lives Matter and what went on the last couple of summers and what's going on now, even around the issue of how much debt students are saddled with. Students are protesting that, or students are protesting, teach us the truth, when there are school boards that want to sanitize the curriculum. All of those things are necessary, but I think the Southern Manifesto went a long way toward getting African Americans to get out there. Martin Luther King Jr., one of his first pilgrimages, you can call it a march on Washington, you can call it a prayer vigil, was to Washington, D.C., in the wake of the decision in Brown, trying to demand that Congress comply with the court's decision in 1957. His first act, 250,000 people. He did that for 3 years in a row, came to Washington, marching with that demand. So the Southern Manifesto, I think, really got black folks, really opened our eyes to the fact that if things were going to change, the courts were going to need a little help, and that help was going to have to look like us. So I think that was missing in the discussion today.
Question in the back?
So there's been a lot of discussion.
Name and affiliation.
Okay. Oh, hello everyone. My name is Kiana Ralph, and I am a part of the Bail Sullivan Leadership Fellowship cohort. And so I'm just thankful to be here and thankful to have heard and gleaned from so much wisdom and just so much expertise in this area. It's really been a huge blessing. And so thank you to all the panelists. So I know that a couple of things that have been mentioned revolved around family and the integration of family and the movement. And I know that the family structures today look much different from what they looked during that time, but I'm curious as to what practices can we take from then and apply to our modern day movement to make sure that that it involves a multi-generational approach, that we have families together advocating for the various needs for our community. And so I'm just curious, looking back to what you may have seen then, what are some of those practices that we can apply and help better our communities with a holistic approach?
Well, I think it's an excellent question. And I want to first assure you that regardless of how it shows up, family is family. And there have always been single parents. That's something that didn't just happen on your watch. There's always been gay parents. There's always been, anything that's happening today was happening back in the day. So let's get that off the table right now. I think what was different was we subscribed more to the it takes a village concept. Our churches were the first and largest and most effective social service agencies in our communities. We rallied around those churches. Our schools came second. But those were the places we looked to. Those were the safe spaces where we could go and where we could meet, where we could plan, where we could strategize, where we could air our grievances about what life was like outside of those doors. I think what's different is we don't have those beacon institutions that we once had. We don't have, the church is no longer looked at as the beacon institution. The NAACP is no longer looked at in that way. The schools, because now they're integrated, and even when they are segregated, they're still not looked at in that way. So I think the challenge is, how do we create that safe space where we can come together? And on top of that, we have to be ready to support one another. We were ready then because the pain was equal. It was EEO, okay? So I don't care if you had a new Cadillac every year, which was the car of choice, or new Buick, my father's car of choice. It didn't matter. The pain was equal. So I think that we were more willing to come together and support one another in that way. Now, when integration came about, some people like to call it the integration, when that happened, because what Brown successfully did immediately was it dismantled the legal framework for segregation. And then it dismantled the legal framework which made it possible for the next Supreme Court decision after the Montgomery bus boycott, and the Voting Rights and the Civil Rights Act and the Loving case and all of the things that came after. But what also happened was for those people that were able to be prepared for the opportunity that presented itself, after the Civil Rights Movement in particular. And they were able to get that paper and maybe become that administrator, that teacher, maybe become that college prof or, partner in that legal firm, and they leave the community. Well, they take with them, their willingness to support, any kind of activism that emerges that's left behind. Because there is such a thing as being worried about, and rightfully so. Now you've got bills and a family to take care of, and so there's a different kind of risk. This is not an easy life to live as a person of color. We wear many faces. We wear many hats. We know how to operate in many venues. That's not going to change. But I think what did change is our willingness to continue to coalesce with our, what we viewed perhaps as our less fortunate brothers and sisters who weren't ready to take advantage of the opportunity, who fell prey, to some of the things that still plague our community. But no, family is still what it was. I just think we don't have those beacons any longer.
Sure. Question right here.
We've talked a little bit.
We have a mic coming for you.
Oh, I'm sorry. Oops, sorry. We talked a little bit today about the problems with implementation of Brown and integration generally. How did things work in Topeka after the decision?
Oh, that's a very good question. What Topeka did, as I mentioned, there were the 22 elementary schools. It was only elementary school. My mother, who started elementary school in 1926, and just a quick lesson, history lesson, my mother's parents were sharecroppers. So I'm only a generation removed from sharecropping. They were sharecroppers in Marvell, Arkansas. And my grandfather came to Kansas, came to Topeka, because word was out, Kansas was getting the word out, that you as an African American could work for the railroad, and you could be a member of the union. So he caught the train by himself, left my grandmother, my mom, and her brother on the farm, and came to check that out, discovered it to be true, and then sent for them. So my mom was 2, her brother 8, and then my grandfather's brothers followed suit, and so the family all ended up being in Topeka. So they came there for that reason. I want you to understand this. My mother, we lived in that same neighborhood, so she rode that same bus and all of that and went to the Monroe Elementary School. So in 1926, when the building was new, my mother was a first grader. They didn't have kindergarten then. So from first grade to 8th grade, you went to elementary school. 9th grade, you went to junior high school, integrated, and then you went to high school, integrated. So high school, however, curriculum was integrated, academics were integrated, but extracurriculars were not. So there were 2 football teams, 2 basketball teams, 2 cheerleading squads, 2 proms, segregated extracurriculars, funded by the school district. So when you came to school on the night of the school party, there was an African-American man that worked for the school board at the door to tell you in which part of the building your party was. So my mom had been elected all-school queen by the African-American students. She was also the National Honor Society, the only African-American female that year. And the African-American king and queen would go to the part of the building where the white students were having their party, and then the white king and queen would go to the part of the building where the African-American students were having their party, just kind of flipping the royalty of the party. But that's how they handled it. So after Brown, since we already lived in integrated neighborhoods, our neighborhood was an immigrant neighborhood, Russian immigrants and others. There were 3 black families in the neighborhood. Everyone in Topeka lived in an integrated setting. We worked in integrated settings largely. Finally, at the church my dad was assigned to, his assistant pastor at an AME church, African Methodist Episcopal Church, was a white minister. So we were always in these situations. Not only that, and everybody African American in this room, and some whites probably as well, will recognize that our families by blood were always very diverse. We had that white grandmother, or that uncle, that it was just who we were. Or maybe we had that, that Asian who was dad's sister's brother's wife. I mean, everybody was always around by blood and by associations. So this was not anything unique, scary, or challenging. So what Topeka did after Brown, immediately obeyed, immediately complied. So in the fall of 1954, schools opened their doors. No, they did not close. Someone mentioned earlier, I think he left the room, that schools in Topeka closed. They did not. The black schools did not. They were integrated. Washington School probably held out the longest as an African-American school, and then it too integrated. So the Monroe School that I'd mentioned, where my mom had gone as a first grader, became an integrated school. By then, my sisters were out of elementary school. So for our family, 1926, when mom went until 8th grade, married dad, had children, then they go there as a segregated school. My sisters grow up, get married, have children, then their children attended that school, same school as an integrated school. I finished college, come back as a teacher. I taught school there as an integrated school, and then I was there until it closed. And then, as you read in my bio, that was the school that I'd worked for very many years on creating a national park in that building. So we had an intergenerational relationship with that particular building, although I'm sure that's probably true, for other African American families in Topeka. But what they did do for 1 year, they integrated faculty and students, not just students. So they sent out a memo to all the white parents saying that, for example, J.B. Hollums, a popular African American teacher, had been a principal, that if your white child was going to have a black teacher this year for that grade, we need your permission. So what they discovered, that not only did they not get permission, people thought it was pretty silly. And so they did it for 1 year. It was a policy that was in place for 1 year, and then it dropped. However, in 1953, before Brown was decided, the school board sent a letter out to the African American teachers who had been teaching 3 years or fewer, telling them that if the plaintiffs succeed in this case, you won't have a job, because we are convinced there won't be enough white parents that will allow you to teach their children for us to retain you. So they didn't wait for the ink to dry on Brown v. Board. They let them go. So those teachers left the state of Kansas. We met some of them over the years, Colorado, Oklahoma, to continue their career. They were angry. So Brown v. Board was not one voice. There were people that were angry with the families that signed on with the NAACP. My father was worried about the teachers and what would happen to them. People were worried about repercussions in that way. So we were the same yet different.
Okay. Question on this side? Question in the back.
Hello, and I'm so appreciative that you're here. My name is Chanel Helm, and I'm also with the Bailey Sullivan Leadership Institute with BAYO. One of the things that struck me the most of what you were talking about was having to correct your history. And I do organize within the Black Lives Matter movement, and that's something that we really struggle with, even in its short period, is correcting that narrative and making sure that you carry your narrative. I'm supporting a young teen right now, and she's a senior in high school, and last year she started Black History Matters, and we're forcing the state to implement Black history into the curriculum. She currently teaches teachers on how to implement that into their classrooms. But recently, we know, like a lot of books, like you said, some books had the story incorrect, and they've been, whitewashing our history, making it, lively, forced immigration, and, they had to come find work. How are y'all going about, finding those entities and correcting that story? Is that something that you do?
We have attempted to do that, and it's very difficult. And it's very difficult because one of the things we've learned is that a lot of the majority of the textbook companies are not owned by U.S. concerns. And so there's certainly not a passion there, to make sure that our history is told in that manner. A person gets a contract to write a few line inches in a book about Brown v. Board, no research takes place. And one of the things that really angered me was 2004, the 50th anniversary, when so many people got very busy writing these books. Scholars are writing books, and boy, they were throwing it against the wall big time. And I guess it frustrated me because we're not hiding. The folks with Briggs v. Elliott can be found. The people with Davis v. Prince Edward County are right here. The people with Belton, Beulah v. Gephardt, are out in the open. Brown v. Board and the people still living with our case, we're not hiding, and we'll certainly pick up the phone, Google, whatever. So to write in 2004, to continue this narrative that doesn't resemble the truth, was disheartening, shocking, and infuriating, to say the least. One of these books, and I won't name the name of the author, said that my father decided to do this because God told him to. Now, first of all, it made my father seem a little unstable, although my father was a man of the cloth, and we absolutely are people of faith and pray on a regular basis. But the suggestion he was making to the lay reader was that somehow, this was a message that he was acting on. I was just so incensed that in this day and age, that you don't do your research. And that's why when we talk about scholars, and there is a place for scholars. We need them. We need the journals and the publications that you put out, whether it's publish or perish, whatever reason you do it for. We need it. But we also want you to do your homework, you know, and the internet is not the place. You know, primary sources are good things. You know, libraries and archives and poring over the collections of people that are out there. So it is a huge, huge undertaking. I'm not convinced we're going to succeed because there is money involved, textbooks and that economic engine, selling books in Florida and Texas and California. You think they're going to listen to me coming from Kansas? You know, I'm going to move to Florida though, so maybe I'll have a bigger voice. I'll be representing Florida. But it is a challenge. So I think Black History Matters is an excellent place to start. That's why we started developing curriculum. We have curriculum that we develop on Brown at every grade level, from primary grade to elementary to middle school, high school, and adult. And the teacher kits with teacher guides and DVDs and questions you can answer. You can spend weeks on Brown v. Board because the bottom line is, like multicultural education, if you do it right, you can use the lens of Brown v. Board to look at so many sociological phenoms that you could be at it for weeks. You could look at geography through the lens of Brown. You know, you can look at how dominant and subordinate relationships evolve through the lens of Brown. You know, it is huge. And so we encourage teachers to be innovative in how they use Brown as a jumping off point. But we are working on that. There was one more point I was going to make, but I'm having a senior moment, so it may not come back too quickly. But we are working on that. I want to, you know, assure you.
Well, as we close tonight's event, first of all, I want to thank you for being here. You mentioned moving beyond the internet, primary resources. You are a living primary resource along with everyone else here. So on behalf of AEI, I want to thank you for what you've shared. In a couple of minutes that we have, what are some parting words for those in the audience as well as those in the viewing audience? What can we do to support your work?
I appreciate that question, first of all, because it goes back to the last question that was asked. I think that there is something to be said for cliches, that if we don't know our history, we are destined to repeat it. The political season we're now in is a prime example. We're repeating some pretty unpleasant history in the rhetoric that's coming out of one of the campaigns in particular. So what you can do to help us is to make sure that the education, the foundation that our children so badly need in terms of understanding the civil rights movement, understanding that it was a youth movement, that alone should motivate them. You know, there is a phrase out there now among academics about the achievement gap and all of that, and it's called stereotype threat, meaning that perhaps African-American children don't perform sometimes because of the threat of being stereotyped. You know, there's also the suggestion that I'm not a fan of the term acting white. I don't believe it's a valid term. I think what we're referring to is that any time African-American children subscribe to the practices of the majority culture, okay? And we all know that that is the culture of commerce, and in this country, it's the culture of success. So we need to talk about that in different ways, because if you talk about it in terms of acting white, it's off-putting, and our kids are not going to listen, and you're going to turn off a lot of audiences. So I think we need to talk about it in terms of the culture, the cultural expectations it sets up, and all of those things. So what you can do, visit our website at brownvboard.org, and you'll learn more about each of the cases. There are ways to support us financially in terms of making sure we can continue with our teacher workshops and continue keeping our curriculum in stock. We have one particular resource that's wildly popular because it's consumable and it's for younger children, but it's an activity book where kids can practice the tenets of Brown. One of them is find your way, it's a maze, find your way to the Supreme Court. But you have a stop-off at the NAACP. Then you have a stop-off at the lower court before you can find your way through the maze to the Supreme Court, through all kind of barriers. Just a very, very simple things. But simple things translate, and they can make their way into the consciousness of that young person. So we cannot give up. And I think your being here is a testament to that. So yes, we would appreciate your support and visiting our website. Thank you.
Well, I would like to thank all the panelists for today, those on panel 1, 2, and 3. I want to thank you for the conversation. I want to thank the families who are here, living history of what we've done. Parting words for all of you. It was mentioned earlier, 60 years ago, Congress members not too far away from here signed the Southern Manifesto. Gave the idea that states' rights were important, gave the idea that freedom of choice is important. It began to materialize into something different than maybe what we would have thought. Today, we still hear conversations about states' rights. We still hear conversation about freedom of choice in parents. A part of what we have to do in our nation is to have a dialogue about what it means. We'll find ourselves on different sides of the fence, but as long as we keep the idea that we want all children to have access not only to a quality education, but access to what it means to fully inculcate what we said in the Declaration of Independence and the Constitution, and we can do that. So I want to thank all of you, and thank you for tonight.
Thank you. I believe we're off air, but I wanted to say this off air, and if we're not, it's fine.
Okay.
Somebody mentioned multicultural education earlier. My senior moment is over. And what I wanted to say was, because I try to always talk about this with university audiences, that multicultural education is also one of our great hopes.